Welcome to Requiro. Today we are going to be talking about updates in Luigi Mangione's case. Now, these updates are from October 10th, 2025 all the way up to November 25th, 2025. You guys already know I took a month off, so I have literally like 2 months worth of documents to go over here. And I know I said in my last video I would go over and talk about the hearings in this video, but just because how much there is and all the little itty bitty pieces of information coming out in Luigi Mangione's case in the hearings, and it's gone way longer than like 3 days. Like currently Luigi Mangione's next hearing on the 12th of December 2025. Nice voice over me. We also got recent updated information. Luigi Mangione will have his next court appearance on the 16th of December 2025 as well. And it was originally only meant to go for like 3 days. That was on December 1st, 2025 to December 2nd, 2025, and then the 4th of December 2025, but then it ran over time and then they had to do another day, and that Luigi Mangione was meant to appear in court for the 5th of December 2025, but then Luigi Mangione got sick, so they moved that date to Monday the 8th of December 2025, and then another day happened when Luigi Mangione showed up in court for the 9th of December 2025, and then also now on the 11th of December 2025. And also, as me saying those dates, there's probably going to be more dates added when I'm editing this video for Luigi Mangione's court hearing, so I've already dated this video already with information. I do apologize. New court hearing literally the next day or the day of after everything has happened, and I'm not in the US, so I don't see it when it happens. I'm asleep. So Luigi Mangione's court hearings have been happening for a while now, so I will make it its own dedicated video just because all the little information coming out on Luigi Mangione's case and just how big it actually has been. So again, my apologies. I was intending to have it in this video, but just because of how big it is and how much there is, it's going to be its own dedicated video. I'm not sure when that video will come out. I do want to wait until all the transcripts come out so we have all the accurate information coming out what was happening in the courtroom. Now, I do know there were journalists live tweeting in the courtroom when Luigi Mangione is having his court hearings, but like you guys know, it's the media. We don't truly know how accurate their live tweeting is because there could be some bits they're leaving out, there could be things they're leaving in and not giving context, so that's why I'm a little bit biased about it. And also, even if that's like the only accurate information we're getting at the moment in Luigi Mangione's case is the live tweets, I am a little bit annoyed about that because I also don't have Twitter, and also like it does get a little bit scrambled over there if you're not there watching the live tweeting when it's happening, and I am asleep when they are happening. So I will go over Luigi Mangione's court appearance when we have the transcripts, so we have the full information what's going on in Luigi Mangione's case, instead of just me relying on the live tweets, even if that's the only thing we're getting at the moment. Also, I do want to say, you can clearly tell there's a bed sheet here. Reason why is literally I am moving soon. I've not found a place, but I want to be prepared, and I packed up all my books. So there is literally no books here, and it is very bare, and this is really nice lighting where I sit. You guys just have to deal with my bed sheet because I don't want to sit in front of a empty bookshelf. It's a little bit sad. Also, I did originally film this 2 days ago. Luckily, it was only the notes I have from Aaron Fillo's motion that came out on the 10th of October. That entire footage of that hour me recording is just blurry, so I have to like refilm this, and I'm a little bit annoyed about that, but whatever. Anyway, I'm not wearing the same outfit as yesterday. You are. Are you guys okay? Are you wearing deodorant? Have you eaten today? Please do. So I do really want to bring this up here. So on the 8th of December 2025, we did get a glimpse of Luigi Mangione's wrist, and you can clearly see there are dents in his hands from the handcuffs of like how tightly they were on him, and it is very alarming to see like how tightly they have the handcuffs again on his wrist. Like those handcuffs, if they could get any more tighter, they could cut him and injure him, and I am quite concerned about that. And sadly, compared to the September hearing, we didn't really get any like side photos of Luigi Mangione, so we couldn't really see what his wrists looked like on like side angle. We only got front photos of Luigi Mangione, but we did get that little glimpse of the 8th of December court hearing where Luigi Mangione, I think, held his fist up. I saw a photo where it's like slightly above. He was like fixing something on his shirt. That's why it looks like that. But we did get a little glimpse of what the dents of the handcuffs on his wrists, and it's very sad and kind of alarming. And then also on the 4th of December 2025, there is a little glimpse of his hand, and you can also see the dents from the handcuffs being really tight on Luigi Mangione before they took him off. I do want to say thank you to this person on Instagram. They have a much clearer photo of the dents from the handcuffs on Luigi Mangione's wrist on the 4th of December 2025. I just wanted to bring this up and bring awareness about this because I did it in the September hearing and not many people were talking about it, and it absolutely should be talked about. It was very alarming. Luckily this time around I couldn't see any bruising on Luigi Mangione's wrists, but we don't truly know because he is wearing a suit and long sleeve button up shirt, so we don't truly see his wrists compared to the September hearing where he was wearing his prison uniform and a long sleeve shirt that was pulled up a little bit. And again, it's still very alarming. I just want to make a note of it here because handcuffs, it could cut him and it could get infected, and the conditions at MDC aren't good. But yeah, just want to note that here. It's sad and alarming how tight they have the handcuffs they have on Luigi Mangione, but it is really nice to see they took the handcuffs off Luigi Mangione when he is at the court hearing, so I'm glad they respected that rule and request to have the handcuffs taken off Luigi Mangione so he can be in court hearing and not have the handcuffs and it being attached to his belt. Again, I feel like it's another way for them to dehumanize him. Again, it's very sad. And also I noticed his knuckles were quite red as well on the 8th of December and also on the 4th of December as well. You can see his knuckles are quite red as well. I'm not sure if that was like just him clamping his fist, because you know your knuckles do change color when that happens. And then also he has really big bags underneath his eyes in those photos as well, like he's not sleeping well whatsoever. I just want to note those things. But we have seen photos of Luigi Mangione coming out from the court hearings, but not in the live streams that have been going on. They don't want to walk him down the hallway when he looks very nice and presentable. Again, it's another way for them to dehumanize him, I think, anyway, for them to walk him down the hallway with all the photographers, media and all that, because, you know, they want to dehumanize Luigi Mangione instead of making him look like a real human being and just treat him like a monster and an animal. It's very sad and very depressing, I think, anyway. But I just want to note that here before we get into the main bit of the video. Also, I have a quote from my mom I need to share with you all. Hi, it's voiceover me. I just want to let you know this quote was towards me, not other people. Just thought I should let you know. And yeah, she said it in that exact type of tone. She says, "You need to stop reading documents about Luigi and go outside and make friends." No. Like, she knows I make these, but she doesn't know the extent I make these. Like, she doesn't really care about this whatsoever. So, I think it's a little bit of a good thing, I think. You guys appreciate it, and I think that's the main point. Anyway, I thought I should share you that beautiful quote from my mom this week. And all the information and all the sources I used in this week's video will be up on the website on this week's episode, so if you want to go check it out, it will be all there, and that will be linked in the description down below. And if there's anything I missed or anything I got wrong or anything like that, please let me know in the comments down below, and I'll sure to pin it or bring it up in my next video. I am one person working on all these videos. There is no team or anything like that here. It is just little old me doing all this here. So buckle up, this is going to be a big one. I literally have 2 months worth of documents to go over. Now let's get into the video. And the days me filming this video, it is the 12th of December 2025 and also the 13th of December 2025 as me recording this video. The 10th of October 2025. A couple of documents did come out on this day, but the main document that came out on this day is the motion from Karen Arcafillo, and I made a full video just making a audio version of that full motion, so go check it out if you haven't. This is just me breaking down the motion so it's more understandable and digestible for you guys instead of the legal talk the document is. So this is what they're going to be talking about in this motion. This is what they are going to be arguing and wanting to suppress at Luigi Mangione's court hearing on December 5th, 2025. So in this motion, they are going to be arguing and wanting to get rid of and dismiss basically counts 3 and 4 against Luigi Mangione because it lacks anything basically proving those to be put on Luigi Mangione, because we will go further in the document. You can clearly see what they're using to have those put on Luigi Mangione, and those are carrying a firearm with the act of committing violence, and also the use and carrying of a weapon to commit a act of violence. Those two rules sound very similar, but they are different. They are just incredibly similar sounding. And they also want to suppress all the evidence found in Luigi Mangione's backpack because it was illegally searched. I do want to add, multiple times without a search warrant. The body cams were switched off. We don't know what happened in that time frame. Just want to add that there. And they also want to suppress the statements Luigi Mangione made to police before his Miranda rights were read to him. I do want to add, it was 20 minutes before they read Luigi Mangione his Miranda rights once the police got to the McDonald's. Just want to add that here. So that's what they're going to be arguing in this motion and wanting to get rid of and dismiss. It's going from page 2 to page 14. It basically is them going over when Luigi Mangione was arrested at the McDonald's. Now, I don't want to repeat myself, and as also mentioned in the document as well, just because the state case and the federal case, they are incredibly similar. So things said in the state case will be basically mirroring things in the federal case, if that makes sense. So I don't want to repeat myself. So if you guys want to hear me break down and talk about the Luigi Mangione was arrested, I do recommend to go watch my video here where I go over and talk about the breakdown and arrest of Luigi Mangione when the police arrested Luigi Mangione at McDonald's. Because again, I don't want to repeat myself. Again, these documents are very similar, so again, go check it out if you want to hear me talk about that and break down, but I'm not going to cover and break down in this document that little bit, because again, I've done it in the past. It was brought up in the document, basically the charges 3 and 4 put against Luigi Mangione. The prosecutors are using the stalking charges they have against Luigi Mangione to have those charges put against him, and they go in depth in the document basically explaining the stalking charges they have against Luigi Mangione towards Brian Thompson does not relate or connect to basically the charges 3 and 4. Like, they're trying to connect dots that literally don't exist. Like, it's crazy. Like, there's nothing there, and they, even with the modified updated version of those rules for having it a digital reason for the stalking charges against Luigi Mangione to have, it still does not relate to have those acts 3 and 4 that the prosecutors are using. They are putting on Luigi Mangione and using the stalking charges to have those claims. Like, literally, the stalking charges they are using to claim the act of violence is not there whatsoever. Like, they're trying to connect dots that aren't there. There's like nothing there. So they go in depth in the document basically discussing the charges to have stalking charges against someone in this document, and they also go over a little bit They go over this briefly in the document, like maybe a stalking charge would be put against someone with an act of violence if, trigger warning, they are doing the violence towards themselves, like self-harm, or basically convince someone, oh, if you don't do this, I will hurt myself. A really good example of this would be in The Notebook. It's a dumb film, I don't really like it, I've only seen little bits of it, but say the scene of basically the guy who's dangling off the Ferris wheel asks asking the girl to go out with him when she's clearly on a date with a different guy, and she says yes, obviously, because she doesn't want to feel like she causes that man to drop off the Ferris wheel and die. That is a good example of the act of violence towards someone, and that is not even in the case of this whatsoever. Again, the prosecutor's documents, where they weirdly run with that for way too long for some reason. Like here in the document, they mention that briefly. That would kind of be the only way of active violence would be towards someone if they did that in a stalking charge compared to someone is not. If that makes sense, like, the prosecutors ran with that for way too long. You will notice that when we get to that part of the video, but like, they focused on that way too much in the motion. It was really weird. And in reality, that kind of stuff was not there whatsoever. The charges 3 and 4 they are claiming and using the stalking charges against Luigi Mangione to have those claims don't fall underneath the definition of those charges to be put against Luigi Mangione. So basically in the document, their request, basically they need to throw out charges 3 and 4 because literally there's nothing there connecting stalking charges against Luigi Mangione to like acts 3 and 4. Like, there's nothing there for them to connect to have those charges put against Luigi Mangione. They should basically throw out literally acts 3 and 4 against Luigi Mangione underneath the rule 12b3 underneath that rule, and cases have been thrown out entirely just because of that rule. So that's what they're saying here. That's what should happen. And I'll pop up on screen for you guys what that rule means, because, you know, we all don't know what legal talk means. I'll pop up on the screen for you guys.
Rule 12b, 3b. Rule 12. Defenses and objections, when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, pre-trial hearing. B. How to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party may assert the following defenses by motion. 3. Improper venue. B. If the court grants a motion for a more definite statement, the responsive pleading must be served within 14 days after the more definite statement is served.
So now we are going to move on to the second part of the document, where they go over and talk about in detail basically everything they allegedly found in Luigi Mangione's backpack should be suppressed because literally the Altoona police force just failed to do their job correctly. Because again, they searched his backpack multiple times without a search warrant. They definitely need that. Basically, it's brought up in the document because Luigi Mangione could not reach his backpack whatsoever, because literally there's like 2 police officers between him and his backpack, and it was 6 feet away from him. Literally, Luigi Mangione does not have any control over his backpack, and his backpack was illegally searched, and that the only time it would kind of be okay would be literally when Luigi Mangione would have control over his backpack and he would be near it and he would be able to reach it. But in reality, it was 6 feet away from him and he could not be near it whatsoever. Explains Luigi Mangione's backpack was searched illegally multiple times because, like we all know, the person who searched Luigi Mangione's backpack, she originally searched Luigi Mangione's backpack and then realize, oh, I shouldn't be doing this, I need a search warrant, and then use the bullshit excuse, oh, she was checking there was a bomb. If you guys push 2 brain cells together and think a little bit more harder about that, that literally makes no sense. Why would you search someone's bag if you think there is a bomb in it? If there was a bomb, you would have to evacuate the area, get the bomb squad involved, and then they'll check if there's a bomb in it. But in reality, she did not do that whatsoever. She just looked through the bag willy-nilly, and then also on top of that, she put the bag that she saw there was a bomb in it in the police car she was driving, I want to add. And also as well, it's brought up in the document, another police officer brought that up saying, oh, if there was a bomb, we would have to like evacuate the McDonald's and get the bomb squad involved. Like, what the fuck? And then also it is brought up the multiple times Luigi Mangione was patted down as well on top of that. So after Luigi Mangione was arrested and taken to the police station, Luigi Mangione's backpack was searched multiple times without a search warrant. And also the body cam footage from that police officer who put Luigi Mangione's backpack in her police car after saying there was a bomb in it. Why would you put that in your car if you think there's a bomb in it? Make it make sense. And basically she turned off her body cam. We do not know what happened between that time frame between the McDonald's itself all the way to the police station. Her body cam footage was turned off. We do not know. That time frame is missing. And same thing at the police station. His backpack was searched multiple times without a search warrant as well by her and also other police officers at the station. Now several hours later, they finally got a search warrant to search Luigi Mangione's backpack, but between the McDonald's and then also they got the search warrant, Luigi Mangione's backpack was searched multiple times, and we do not know what happened in the span of that time frame of when they got Luigi Mangione's backpack and until they got that search warrant to search his backpack. So anything could have happened in the span of those hours, allegedly. Basically, in the document they explain everything in Luigi Mangione's backpack should be suppressed because they did not get a search warrant to search his backpack, and his backpack was searched multiple times. Like I explained before, there's a massive time frame we do not know and we do not have of when Luigi Mangione's backpack was searched multiple times without a search warrant. And basically the Altoona police force basically failed to follow protocol, and they basically failed to follow Luigi Mangione's right of the Fourth Amendment. So that's why basically everything in Luigi Mangione's backpack should be suppressed. Now we are going to be moving on to the final part of the motion, where the statements Luigi Mangione said to police, because literally it was 20 minutes before Luigi Mangione was read his Miranda rights after police got to the McDonald's. Officers came to the McDonald's and they specifically stood in a way making sure Luigi Mangione couldn't get out. Like we've seen from the body cam photos, they very much put themselves in a position so Luigi Mangione couldn't get out unless he would jump over the table, and anyone in that position would definitely think they are underneath arrest no matter who they are. I would, Luigi Mangione would, anyone else in that position would definitely feel like they would, and if Luigi Mangione did jump over the table, that would make Luigi Mangione look more suspicious, even if they were claiming Luigi Mangione was not underneath arrest or questioned at the time. But literally anyone in that position would think they would, because literally how the police officers were trapping him in. Multiple times they asked Luigi Mangione questions like where he is, where was he on this date and this time, and why did he have a fake ID before Luigi Mangione was read his Miranda rights. And also, it's brought up in the document, even after the police officer that was questioning Luigi Mangione, he was reminded he needs to tell Luigi Mangione his Miranda rights, he still did not do that and kept asking Luigi Mangione questions before told Luigi Mangione his Miranda rights. Literally, he was told to frickin' do it and then he didn't. And then also another officer as well asked why did Luigi Mangione hand over a fake ID. Again, Luigi Mangione's Miranda rights were still not read to him in this moment in time, and the officer asked Luigi Mangione was he in New York. He was specifically waiting for a response so he knows he got the right guy straight away, because he was waiting for a response to say, oh yes, I was in New York, oh no, I wasn't in New York. No matter what Luigi Mangione said, anything he would have said, that police officer went in and assumed Luigi Mangione was the right guy, no matter what Luigi Mangione said. We already know that, I've said that multiple times, but it is very true. He went in with a bias towards Luigi Mangione without actually doing any detective work or anything like that. And basically they also bring up the document because the amount of police officers at McDonald's, because they originally came there to say basically, oh, he was there for too long at McDonald's, case of loitering or trespassing, and basically the amount of police officers at the McDonald's would make no sense for that many officers to be there for a trespassing or a loitering offense. Again, You can stay at McDonald's as long as you want. They don't fucking care. Just don't be rowdy, be mean to them. They don't give a shit. So I found that really weird, honestly, when I first heard that, and they told him, oh, you were at McDonald's for way too long. That makes no sense. I don't give a shit at McDonald's. And the answers Luigi Mangione gave to the police, they need to suppress that, because literally for 20 minutes he was questioned, his Miranda rights were not read to him, and anything in that time frame they need to suppress, because they need to told Luigi Mangione his Miranda rights, and they did not do that whatsoever. Again, it's the Altoona police force not doing their job correctly and just jumping the gun, no pun intended. Basically, in this motion, they are arguing they want to suppress all these statements Luigi Mangione made to police. For his Miranda rights read to him, they definitely should, and also everything they allegedly found in Luigi Mangione's backpack, because it was searched multiple times without a search warrant. We do not know what happened in that time frame before they got a search warrant to search Luigi Mangione's backpack, and basically the acts 3 and 4 against Luigi Mangione, they have literally nothing there to connect the violent charges they have against Luigi Mangione with the stalking charges they are claiming to have those charges put against Luigi Mangione. So that is what they're claiming in this motion and what they should suppress and get rid of in this motion. I really hope I'm explaining this really well and breaking it down. I'm not sure at times. I'm genuinely serious. I don't know why lately I've just been saying push 2 brain cells together. I think I'm just saying please think for a minute. I don't know why I decided to start saying that. I've been saying that twice in 2 of my videos lately, pushing 2 brain cells together. I think I just invented a new saying. I feel like if you did do that with brain cells, they will die. It's like, I know if you hit your head, it does kill brain cells. So now we are going to be moving on to the other documents that came out on the same day as this motion, but these documents that I'm just going to mention the name because literally these same documents are in the motion itself. So basically, if you go listen to the video I made going over the audio version of the document, it's all there, and these documents just came out separately as well on the same day. See, prosecutors, this is how you write a motion. You keep all the freaking extra stuff in the motion itself instead of having them separately. This is how you do it. Do it what Karen does. I sound like an annoyed parent. I'm still very annoyed about that. So the first document was the notice of motion. Again, these documents were in the actual motion itself. And then the next document was a oral argument. And the next and final document was a Exhibit 1 document. The 14th of October 2025. So a couple of documents came out on this day. So this first document I'm going to show you guys, it is from Karen Arcafillo. This is Karen Arcafillo's response to the government's response when Donald Trump and a bunch of other politicians said a bunch of things about Luigi Mangione and not said alleged or anything like that. So that's what this document is. So I'll pop it up on the screen for you guys.
October 14th. 2025 via ECF, the Honorable Margaret M. Garnett, U.S. District Judge, Southern District of New York, 40 Foley Square, New York, NY 10007 Re, United States v. Mangione, 25 CR 176, MMG, Dear Judge Garnett, pursuant to this court's September 24, 2025, order, the government submitted a letter on October 8, 2025, addressing whether certain statements made by Department of Justice personnel violated Local Criminal Rule 23.1. We respectfully request that this court allow counsel until this Thursday, October 16, 2025, to file a brief reply to the government's letter. Thank you for your consideration. Respectfully submitted, Karen Friedman Anafilo Mark Anafilo Jacob Kaplan CC, Gut Counsel, via ECF, Moskowitz Colson Ginsburg and Schulman, via ECF.
Basically, this document is Karen Arcafillo responding to the government's response when Donald Trump and a bunch of other politicians went on TV and said a bunch of things about Luigi Mangione and not said alleged or anything, and also the retweets and all that, and basically saying in the document they did not follow whatsoever what the government requested was them to reply and say, hey, you shouldn't have done this, why did this happen, stop it. But then it kept going, and basically they're requesting the government to respond to what the government said on the 16th of October 2025. So we will get to that part later on in the video, but basically that's what this document was. You guys remember when I read that response from the government's response to what Donald Trump did and a bunch of other politicians did? It was fucking infuriating. Like, I was yelling. It's like such bullshit. Also, on the same day, a order was filed that was granted. So this document came out on the same day as the document from Karen Arcafello, and also the order that was granted for the document from Karen Arcafello. This is from the prosecutions requesting, hey, can we have like more time, please, to respond to Karen's motions? So I'll pop it up on screen for you guys.
October 14th, 2025 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York, 10007 Re, United States versus Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government respectfully writes to request an extension of time to respond to the defendant's pending motions, seeking dismissal of the indictment, challenging the constitutionality of the death penalty, and seeking dismissal of certain counts and suppression of certain evidence and statements. The government's current response date for the defendant's motions challenging the death penalty is October 31st, 2025, and its response date for the motions not related to the death penalty is November 14, 2025. In the interest of efficiency and judicial economy, the government seeks to consolidate its responses and respectfully requests an extension of time to November 21st, 2025, to respond to all of the defendant's motions. This is the government's first request for an extension of time with respect to these motions, and the defense does not object. Notwithstanding this request, the parties remain available to appear before the court on December 5th, 2025, as scheduled, or at any other time the court may deem appropriate. Respectfully submitted, Sean S. Buckley, Attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S. Dominic A. Gentile / June Zhang Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys 212-637-2200 Counsel of Record, via ECF.
Basically, this document from the prosecutors is just saying, hey, can we have like more time to respond to every single motion written by Karen Arcafello? And basically that's what this document is. And I did find it kind of funny where it literally says at the end, this is the first time we've requested a extension for this. And in reality, no, they didn't. This is not the first time. We saw it in the document where you guys were meant to respond to what Donald Trump said on TV. You requested more time then. I thought that was kind of funny. I like looking at my notes. I can 100% tell I literally started doing this after reading the prosecution's motion because I'm really mad in my notes towards the prosecution. The 15th of October 2025. This is a document from Thomas Dickey basically saying Luigi Mangione's case happening in Pennsylvania has been put on pause because literally everything going on in New York. So very exciting stuff because literally how can Luigi Mangione be there in person when he's busy in New York? So please take this document with a little bit of skepticism. I did get this from Reddit. So I'll pop it up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania versus Luigi Nicholas Mangione, Defendant Hon Jackie Atherton Bernard Pete Weeks, Esquire Nicole Smith, Esquire Thomas Dickey, Esquire number 2024 CR 2724 WA Presiding Judge District Attorneys. First Assistant District Attorney Counsel for Defendant Order and now, this 15th day of October, 2025, entry of the following order is deemed appropriate. It is hereby ordered, directed, and decreed that 1. The court previously received the defendant's response/objection to the Commonwealth's notice of federal government denial of habeas corpus ad prosequendum, which states, the defendant demands and insists that he be present in person for any and all critical stage proceedings in Pennsylvania and will not agree to waiver or diminish in any way his right to be present is protected by the Constitution of the United States and of this Commonwealth. Paragraph 6 of the defendant's aforelisted filing. 2. In response to the court's order dated September 29, 2025, the Commonwealth filed its second notice of the federal government's denial of writ of habeas corpus ad prosequendum, along with correspondence from the United States Attorney for the Southern District of New York. Sean S. Buckley, said correspondence reiterated the refusal of the federal authorities to release the defendant to Pennsylvania until the conclusion of his federal prosecution, including any applicable sentencing proceeding. The United States Attorney further repeated the availability of the defendant for virtual appearances in Pennsylvania Court 3. The court deems the defendant presently unwilling and unavailable to appear remotely based upon the present recorded filings by the defense, making it impossible for this court to convene substantive hearings on any of his pretrial motions or requests at this time. Therefore, those requests for hearing/relief, as contained in his response/objections to Commonwealth's notice of federal government denial of habeas corpus prosequendum, are denied and dismissed without prejudice in the event the defendant's availability changes. Further, the court deems the defendant's unavailability as a waiver of Rule 604. Pursuant to the prior order of court, the Commonwealth remains under an ongoing obligation to update the record in this court every 60 days on the status of the defendant's availability for proceedings in Blair County, Pennsylvania. Additionally, the defense likewise is directed to advise in writing by filing a proper certification of record as to the defendant's demand for in-person appearance, or if he is reconsidered and will appear remotely, said certification shall be filed within 14 days of the Commonwealth's recorded update regarding the defendant's availability for transport by the court. Jackie Atherton Bernard, J.
Basically, in the document it says the case has been put on pause because Luigi Mangione can't be there in person because he's busy in New York, and the habeas corpus has been rejected, and all this has been put on pause until Luigi Mangione is available in Pennsylvania to be there in person. Basically, everything happening in Pennsylvania will be put on pause until Luigi Mangione is available to be there in person, because that is his right to be there in person, and when Luigi Mangione refuses to do it through Zoom. I know I should stop saying Zoom, I think that's a brand, but like, I'm just gonna keep saying it. You guys know what I mean, like FaceTime call thingy-majig ordeal. Anyway, and basically, for Luigi Mangione not to be there, because it is his right to be there in person if he wants to, it is covered underneath the Rule 600, and they will update every 60 days for Luigi Mangione's availability to show up in Pennsylvania, and if there's any changes or anything like that, they have to update in the span of 14 days in writing, confirming the changes after that. I am like really glad this has happened, because one, Luigi Mangione is literally dealing with so much right now and he can't be there in person, and it is his right to be there in Pennsylvania in person, so I'm glad this has been put on pause until Luigi Mangione is available. And I think many people have mentioned, I can't remember the exact rule, but up to around I think 360 days, if Luigi Mangione still doesn't show up for the Pennsylvania course, everything will be dismissed and it won't happen. So Thomas Dickey is trying to do here. My thoughts, allegedly, again, it's just my thought and what I've seen, what a couple of people have said about this. So again, Luigi Mangione in Pennsylvania has been put on pause until he is available to be there in person, if it doesn't get dismissed because he has not showed up in the span of 360 days. Please correct me if I'm wrong with that date. I know it's like a certain amount of days, but I don't remember the exact number. So this is another document that came out on the same day. So this is the denial of the rejection of the habeas corpus. Please take this document with a little bit of skepticism. I did get this from Reddit, so I'll pop it up on screen for you guys.
Sequence number CP. File date. Document date. Filed by service to service by issue date the 10th of June 2025. Service type E. Service status date. Service status served the 15th of October 2025. The 15th of October 2025. Bernard, Jackie Atherton. Order denying, dismissing request for hearing/relief to federal gov denial of habeas corpus prosec. Blair County District Attorney's Office. The 16th of October 2025. E-service served. Dickey, Thomas M. The 16th of October 2025. Service served.
Also, I'm kind of noticing this. A lot of the documents from Pennsylvania I literally don't have access to. Like, I've clicked on links to Pennsylvania stuff in this case, and I get a blank page compared to the stuff happening in New York I have access to, but the Pennsylvania stuff I don't. So I'm noticing that pattern. A lot of the stuff from Thomas Dickey I don't have access to. New York, I find that interesting. I did try to click on at one point in time, Thomas Dickey's website, I don't get access to that here. And did you guys hear, the United States government now is gonna be asking for social media if I wanna travel to the United States? That's a step too far. Why do you need to know my Instagram account to travel to an entire different country? I feel like I'm a little bit screwed because I do this kind of stuff. I don't think Donald Trump will like me. Let's hope for a new president to get rid of this dumb rules and stuff in the United States. Oh my god. 16th of October 2025. This is a document from Karen Ocafillo basically requesting to dismiss the death penalty and all the charges against Luigi Mangione because of prejudicial statements from the government. What's Luigi Mangione? I'll put the document up on screen for you guys.
October 16th, 2025 via ECF, the Honourable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York 10007 Re, United States vs. Mangione, 25 CR 176, MMG. Dear Judge Garnett, we write in reply to the government's October 8th, 2025, letter addressing whether certain social media statements made by Department of Justice, Dodge, personnel violated Local Criminal Rule 23.1 in the court's April 25, 2025, order. For the reasons stated below, counsel submits that these statements fall well within the confines of Local Criminal Rule 23.1 in the court's order and were prejudicial to Mr. Mangione's right to a fair trial. 1. The DOJ personnel who made the statements are covered by Local Rule 23.1. The court's instruction to the government could not have been clearer. On April 25, 2025, the court stated, in the nature of this case, I would like to just remind all counsel of the strictures of Local Criminal Rule 23.1 about public commentary about this matter that could impede or affect Mr. Mangione's ability to get a fair trial and the court's ability to select a fair jury in this case. I'm specifically directing the government to convey my directive to Mr. Clayton and request that he convey the same to Attorney General Bondi and any of her subordinates at Main Justice. The 25th of April 2025 TR at 1718, emphasis added. On April 30th, 2025, the government informed the court that it had conveyed the court's directive to the Attorney General. The government also writes to inform the court that United States Attorney for the Southern District of New York, J. Clayton, is recused from this matter. Pursuant to 28 U.S.C. Section 515, Criminal Division Chief Perry Carbone is acting as attorney for the United States in this case. Per the court's instruction, the government has notified Mr. Carbone of the court's admonition regarding Local Criminal Rule 23.1. Mr. Carbone has conveyed the same to the Office of the Deputy Attorney General, which confirmed that it will in turn notify the Attorney General. Page 2 of 10-22, DKT 30 Gov. The 30th of April 2025 letter at 1. This was further confirmed in the government's October 8, 2025, letter, which noted that the government previously communicated the court's admonition regarding Local Rule 23.1 to the appropriate parties. DKT 56, Gov. The 10th of August 2025 letter at 1N, 2. 1. This letter was accompanied by an October 8, 2025, declaration from Sean Buckley, the Deputy United States Attorney of the Southern District of New York, who indicated that the government communicated the court's April 25, 2025, admonition to the Deputy Attorney General's office, and that he personally communicated the court's September 24 order, including its admonition, to the Deputy Attorney General. DKT 56-1, AUSA Buckley Declaration at 3 and N. 1. Despite this court's clear directives and assurances made to this court, the government nevertheless claims that the DOJ personnel who publicly commented on the case are Department of Justice employees who are not associated with this matter. Gov. The 10th of August 2025 letter at 2. This position is factually inaccurate and inconsistent with the court's instruction explicitly directed at the Attorney General and her subordinates too. There can be no doubt that the Attorney General of the United States herself is associated with Mr. Mangione's case, as the Attorney General is the only individual in the DOJ authorized to seek the death penalty in any case. Moreover, the Attorney General has publicly stated that she herself was involved in this specific case, as she publicly directed the Southern District of New York prosecutors to seek the death penalty against Mr. Mangione in an April 1, 2025. Press Release 3. The Attorney General further explained her own reasons for doing so on April 6, 2025, stating the following on the Fox News channel. 1. In its submission, the government notes that, on September 2, 2025, the Executive Office for the United States Attorneys, EOUSA, also recently issued new review and approval processes for any public statements by employees of the United States Attorney's offices at panels, conferences and public events. Further, all DOJ employees are subject to governing regulations and policies of the department. For example, all DOJ employees are subject to 28 CFR 502, an internal department regulation regarding public statements by department employees. Counsel requests a copy of these new rules too. The time to object to the court's order concerning the Attorney General and her subordinates was on April 25, 2025, when the order was issued, not 6 months later, after it was repeatedly violated. If the government had a good faith basis to object to the order, it would have objected. That it did not is further proof that the order faithfully reflected the scope of Local Criminal Rule 23.1.3 upon information and belief, given the cadence and the highly unusual way in which the death penalty was sought and authorized here, which was wholly outside the procedures set forth in the Department of Justice's own policy manual in a capital case. The defense believes that the Southern District of New York did not recommend seeking the death penalty in this case, and that the decision to seek was solely a decision by the Attorney General herself, thereby making her in fact part of Mr. Mangione's prosecution team. Page 3 of 10-3. The President's directive was very clear: we are to seek the death penalty, when possible. It hasn't been done in 4 years. I was a capital prosecutor. I tried death penalty cases throughout my career. If there was ever a death case, this is one. This guy is charged with hunting down a CEO, a father of 2, a married man, hunting him down and executing him. I feel like these young people had lost their way. I was receiving death threats for seeking the death penalty on someone who was charged with an execution of a CEO. AG Pam Bondi accuses district court judges of playing whack-a-mole with anti-Trump lawyer. Fox News Sunday with Shannon Brim. Fox News, April 6, 2025, available at https://www.foxnews.com/video/6,371,377,112. Moreover, this court itself recognized the Attorney General's role in this case by ordering the acting United States Attorney for the Southern District of New York to advise the Attorney General to read Local Criminal Rule 23.1. Therefore, not only is the Attorney General the only person in the DOJ authorized to approve the ultimate life or death decision of whether to seek the death penalty, thus making her part of a prosecution team in cases where capital punishment is sought, she in fact personally made the decision to execute Mr. Mangione and personally caused the grand jury investigation that led to his indictment. Because the Attorney General is associated with the case, and because the court directed her and her subordinates to be informed of the local rule, it is necessarily the case that her employees are also covered by Local Criminal Rule 23.1 as they are non-lawyer personnel employed by a lawyer's office or subject to a lawyer's supervision as indicated in the defendant's letter motion to the court filed September 23, 2025. One of the DOJ employees who publicly commented on this case on the X platform was the Deputy Director of the Dodge's Office of Public Affairs, who works directly for the Attorney General, CDKT 52. Defense, the 23rd of September 2025 letter at 2:43. The other DOJ employee who reposted the X post was the Chief of Staff and Associate Deputy Attorney General for the Deputy Attorney General. Because these individuals are DOJ employees working under the Attorney General, this court should find that they fall under Local Criminal Rule 23.1.2. The social media posts have prejudiced the defendant. The government claims that Mr. Mangione was not prejudiced by these social media posts. Gov. the 10th of August 2025, letter at 2-3. Under Local Criminal Rule 23.1 D, however, there is a class of statements that presumptively involve a substantial likelihood that their public dissemination will for not only is the Attorney General prejudicing Mr. Mangione by giving her personal opinion as to his guilt and the merits of the case, but she also personally inserted herself into the calculus by justifying the decision based on alleged death threats made to her, a wholly inappropriate justification as there is no connection between Mr. Mangione and any unrelated death threats to the Attorney General. Page 4 of 10-4 interfere with a fair trial or otherwise prejudice the due administration of justice. This presumption specifically applies to no opinion as to the accused's guilt or innocence, or as to the merits of the case or the evidence in the case. Local Criminal Rule 23.1 D 7. Here, the social media posts made by the DOJ employees and sent to thousands of their followers discussed President Trump's and the Deputy Director of the DOJ's Office of Public Affairs opinions as to Mr. Mangone's guilt or innocence. 5. The opinion in question, i.e., at POTUS is absolutely right, was referencing an embedded televised statement made by the President of the United States and reposted by an official White House X account that said in part as follows: "Think about Mangione. He shot someone in the back as clear as you are looking at me or I am looking at you. He looked like a pure assassin. He shot him in the middle of the back, instantly dead. This is a sickness." The social media post and reposter included below. 5. The government's characterization of this public social media posting as merely a reposting, not necessarily an endorsement of the original tweet, citing Flynn vs. Cable News Network, Incorporated, 621 F sub 3D 432, 439, SDNY 2022. Fails to acknowledge the posting account indeed endorsed the repost when he added his office's opinion that the President's comments about Mr. Mangione guilt were also held and endorsed by the Attorney General and the DOJ. Page 5 of 10-5, while acknowledging that the presumption of prejudice exists for such opinions regarding a defendant's guilt or innocence, the government nonetheless claims that it should not apply to this case because of the length of time between the challenged statements and the trial. Gov. the 10th of August 2025, letter at 3. In making this argument, the government relies on Skilling versus United States that found no presumptive prejudice where over 4 years elapsed between Enron's bankruptcy and the defendant's trial. Skilling versus United States, 561 U.S. 358, 383, 2010. In Skilling, however, the court noted that with our reporters covered Enron-related news throughout this period, the decibel level of media attention diminished somewhat in the years following Enron's collapse. ID. In contrast, the media attention to this case has not diminished since the alleged shooting in December 2024, as the United States government repeatedly continues to publicly comment on the case, and there are 3 pending cases that the media write about consistently. Moreover, unlike in Skilling, where the prejudice was minimized by the 4-year delay between the prejudicial statement and trial, here the prejudice is more severe because the commentary appears almost daily, compounded exponentially by the reach of social media, and both this court and a state court have expressed an interest in potentially trying the concurrent federal and state cases in 2026. Further distinguishing this case from Skilling, here, since day one, Mr. Mangione has been treated unjustly as part of a coordinated ongoing campaign by the United States government to paint him as a terrorist and violent left-wing extremist, despite there being absolutely no evidence to support these assertions. In fact, just yesterday, October 15th, 2025, at a press conference with the President of the United States, the Director of the FBI, who reports directly to the Attorney General, deliberately named Mr. Mangione in response to a reporter's question about a wholly unrelated case. https x.com/redwavepress status/1978558182382501991. It is also worth noting that the vast impact of social media commentary regarding Mr. Mangione in 2025 further distinguishes this case from Skilling, which took place prior to the DOJ and White House utilizing this medium to communicate to the public. Another distinction between the Mangione case and Skilling, and indeed with any case from outside the Southern and Eastern districts of New York, is the explicit rule of this court when it comes to public statements and pretrial prejudice. In the committee notes to Rule 23.1, the committee states that his rule was the subject of substantial debate and compromise at the time of the 1997 revisions to the local rules. The committee further notes that the rule has not been changed since the time. While the impact of lawyer statements to the press may be different in other jurisdictions that do not have an equivalent rule, the committee that studies cases in New York has concluded that a lawyer's assertion of opinion as to the guilt of a defendant prejudices the defendant's prospects at a fair trial here in the Southern District of New York. There is no indication of what the rules are concerning trials in Houston, where Skilling was tried, or any place else. But the rules in the SDNY represent the committee's learning and experience with criminal trials in the SDNY, specifically that statements of the type here are prejudicial. By arguing otherwise, the government wheels away the experience and substantial debate of a committee tasked with ensuring that trials here are fair. Page 6 of 10 to 6. Consequently, because Skilling is distinguishable, the presumption of prejudice applies here because the above referenced statements, posts and reposts express an opinion about Mr. Mangone's guilt or innocence. 3. Statements made by the White House about this case are subject to Rule 23.1 and prejudicing Mr. Mangione. Unlike any of its predecessors since the Watergate era, the Department of Justice has not acted independently of the White House in this case, or in several others. This departure from the long-standing principle of prosecutorial independence has created a blurred and constitutionally troubling line between the Department of Justice and the Executive Office of the President. As a result, the government cannot credibly contend that statements made by the White House concerning this matter fall outside the scope of Rule 23.1 or this court's prior order, for several reasons. First, the DOJ has endorsed White House statements by reposting them. Second, at least one administration employee reports both to the Attorney General and the White House, the Chief of Staff and Associate Deputy Attorney General for the Deputy Attorney General, referenced above, who holds the simultaneous titles of Chief of Staff and Associate Deputy Attorney General for AG Todd Blanche under the leadership of AG Pam Bondi and POTUS, American flag emoji, meaning he reports directly to both the Attorney General and the White House. Similarly, the President himself has repeatedly referred to himself as the Chief Law Enforcement Officer, 6, while personally directing individual cases, 7(6)(c), for example https://www.pbs.org/newshour/politics/fb searches home and office of X. Trump National Security Advisor John Bolton AppSource says, quoting President Trump as stating, "I'm actually the Chief Law Enforcement Officer." Page 7 of 10 to 7. Third, the Attorney General SDOJ policy rhetoric emphasizes a political agenda rather than the independent, non-partisan traditional role of the DOJ. A recent Politico article's review of the Attorney General's more than 100 public statements since her appointment found that she deliberately appears on significantly more right-leaning media outlets and, as the article stated, has emerged as perhaps the most openly political and partisan Attorney General in modern American history. Political in the sense that she carefully structures her appearances and rhetoric to track the priorities of the White House with no concern for notions of DOJ independence. She appears to conceive her role as an advocate for Trump in particular and for the American right more generally. Ankush Kardori, What I Learned by Watching Every Pam Bondi Speech, Politico, October 7, 2025, https://www.politico.com/news/magazine/the 7th of October 2025 Pam Bondi Speeches Trump Justice Said Mint column 00589860. By issuing the prejudicial statements about Mr. Mangione described above, the Department of Justice and the White House have coordinated to cultivate and disseminate negative public rhetoric, deliberately designed to taint the prospective jury pool. For example, as recently as September 25, 2025, the President of the United States issued a National Security Presidential Memorandum/NSPM 7 countering domestic terrorism and organized political violence, declaring certain individuals as anti-fascist and designating Antifa as a domestic terrorist organization. As part of the President's justification for this declaration, he cites 3 specific cases, including the 2024 assassination of a senior healthcare executive, clearly a reference to the allegations against Mr. Mangione. This declaration was made despite the fact that, only 9 days prior, in New York State Supreme Court, the judge dismissed the terrorism charges against Mr. Mangione, finding that the defendant's conduct did not rise to the level of terrorism, and noted that the federal government also did not charge him with terrorism. The judge held that there was no evidence presented of a desire to terrorize the public, inspire widespread fear, engage in a broader campaign of violence, or to conspire with organized terrorist groups. See People v. Mangione, Decision and Order at 9. Moreover, there is no evidence to support any of these claims, nor does Mr. Mangione hold the political or ideological beliefs that are being ascribed to him by this administration. Unfortunately, there is little reason to believe that the DOJ and White House will stop their concerted efforts to prejudice Mr. Mangione. This is because of UnitedHealth's continued attempts to influence this administration. Following the death of its chief executive officer, UnitedHealth reportedly lost approximately $63 billion in market value, in May 2025. The Wall Street Journal reported that UnitedHealth was under criminal investigation relating to its Medicare operations. 9 Subsequently, on September 14, 2025, the Wall Street Journal published an article detailing page 8 of 10 to 8 UnitedHealth's extensive connections with the current administration. 10 According to that reporting, UnitedHealth obtained meetings with senior officials of the Department of Justice, including the Attorney General's Chief of Staff. The same article stated that UnitedHealth more than doubled its expenditures on lobbying and legal services to $7.7 million in the first half of 2025. Engaging individuals with direct ties to this administration, including persons identified as among the top donors to the president's super PAC. These lobbyists, several of whom are former Department of Justice employees, reportedly arranged meetings for UnitedHealth with senior DOJ officials. The article further recounted that a UnitedHealth chief executive officer met with the White House chief of staff and claimed that they did not discuss the government's investigations into UnitedHealth, but rather addressed other issues. Emphasis added, UnitedHealth's continued financial viability depends upon maintaining the narrative that Mr. Mangione, rather than the company or its business practices, is the villain. Accordingly, the defense respectfully requests discovery regarding these meetings to determine whether the other issues discussed between UnitedHealth and the government precipitated coordinated efforts by the White House and the Department of Justice to malign and prejudice Mr. Mangione. The significance of these prejudicial statements is that they have life or death consequences for Mr. Mangione. The statements have caused irreparable harm because the government's sustained public commentary, designed to further a political agenda, will have a prejudicial impact on a future jury. Since the government is seeking to execute Mr. Mangione, he will already be subject to a more politically conservative jury pool, as any prospective juror, in order to be disqualified, has to affirmatively be willing to execute him as punishment. Literature and studies support that there is a correlation between death-qualified jurors and a conservative outlook. For example, in Lockhart v. McCree, 476 U.S. 651, 1986, the American Psychological Association's amicus brief summarized a social science record that death-qualified jurors are more conviction-prone in prosecution, leaning than jurors excluded for opposition to capital punishment. Available at https://www.appa.org/about/offices/ogc/amicus/Lockhart PDF at pages 6 to 16. Additionally, in a statewide study by Fitzgerald and Ellsworth, it was found that death qualification disproportionately removes twice as many Democrats as Republicans and skews the panel toward a more conservative and pro-prosecution bent. Fitzgerald, R., and Ellsworth, P.C., 1984. Due Process versus Crime Control, Death Qualification and Jury Attitudes, Law and Human Behavior, 8, 1-2, at 46, available at https://capitalpunishmentincontext.org/files/resources/deathqual/due process PDF. The administration's consistent and baseless attempts to paint Mr. Mangione as a left-wing extremist, especially during a time of unprecedented political polarization, will have a significant prejudicial effect on a conservative-leaning death qualified jury who will, as a result, associate him with these viewpoints. Therefore, it is not a stretch to conclude that the administration's attempt to unfairly and inaccurately paint Mr. Mangione as a left-wing violent extremist will have a significant prejudicial effect on this case and his life. Page 9 of 10 to 9 to 5. Remedy sought. As the court is aware, in points 1 and 2 of Mr. Mangione's September 19, 2025, motion, we ask the court to dismiss the indictment in light of the prejudicial and unlawful statements of the Attorney General and others, and due to the government indicting the case while the grand jury prejudice motion was pending before the court. In point 3, we ask the court to dismiss the notice of intent to seek the death penalty. The statements made by DOJ officials since the original motion was filed provide further support for both points 1 and 3. The heart of the defense's concern is that the government has engaged in purposeful, repeated, unlawful actions specifically designed to hurt Mr. Mangione's chances at fair legal proceedings and a fair trial, and as part of a wider government effort to further a political agenda. That these same officials, whether acting directly or through their subordinates, have continued on this course even after this court has explicitly directed them not to, has caused this case to be unlike any prior death penalty case. Counsel cannot find another death penalty case where the trial judge issued a clear, unambiguous order that specified government officials should abide by a critical local rule ensuring that trials in this district are not adversely impacted by prejudicial public statements, only to see that order repeatedly violated and have that violation defended by the government. If the sanctity of a death penalty prosecution means anything, it means that government personnel seeking to execute someone cannot purposely, repeatedly and brazenly violate court rules and a judge's order to gain an unfair advantage so it can have a better chance at killing the defendant. Also, the administration's steady and persistent use of the Mangione case to press a political viewpoint is further proof that the Mangione case was political fodder for the government from the beginning. As an alternative to dismissal of the indictment, counsel asks the court to order the government to provide internal documents, communications and emails that will answer the question the court posed in its September 24, 2025, order. How these violations occurred. The government did not answer the court's question. Page 10 of 10 to 10 to 6. Conclusion. Mr. Mangione is one young man, alleged to have acted alone, fighting for his life in 3 separate cases, against the full force and might of the entirety of the United States government that is actively and persistently using him as a pawn to further its political agenda. This is the very definition of prejudicial, where the consequence is death. For these reasons, as well as the reasons articulated in Mr. Mangione's September 19, 2025, motion, this court should dismiss the indictment or, in the alternative, dismiss the notice of intent seeking the death penalty. Respectfully submitted, Karen Friedman, Anafilo, Mark Anafilo, Jacob Kaplan, Anafilo, Intrator LLP, 140 Broadway, Suite 2450, New York, New York 10005, S. Abby Morskowitz, Elon Schulman, Christopher Neff Morskowitz, Colson Ginsberg and Schulman, 80 Broad Street, Suite 1900, New York, New York 10004.
In this document, they go in detail. Basically, what the United States President said about Luigi Mangione does fall underneath that category of this being prejudicial and affecting Luigi Mangione's case, because literally, he's the President of the United States. People like him. People will take his word at face value. We all know that. We're not gonna go over when people took over the White House. Do you remember that? That was insane. People do listen to Donald Trump. So when Donald Trump goes on TV and says a bunch of things about Luigi Mangione, it does affect his case in a big way because people see him and take his word for it because they like him. So this does affect Luigi Mangione's case in a big way, and the United States government saying no, it doesn't fall underneath that category. It definitely does. Basically, this document goes into detail explaining why it definitely does. And also the letter that was sent from the judge to the United States government basically saying, hey, you guys are not meant to do this, figure out why the hell this happened and don't let this happen again. This can affect Luigi Mangione's case in a big way, and it can dismiss the entire case entirely because of these statements made by the United States government and from Donald Trump. did cover that document from one of my updated videos on Luigi Mangione, where basically the judge saying, hey, what is this? Don't do this. Explain yourselves. And basically the United States government, their response was they blamed everyone else but themselves for this happened, and basically just making up shit saying, no, it wasn't our fault. This won't affect Luigi Mangione's case in a big way. This doesn't fall underneath that category. It definitely does, and this document I just showed you guys very much shows it definitely does. Now, this also relates to, if you guys remember, all the way last year when this first happened in December, the New York mayor, he said a bunch of things about Luigi Mangione without saying alleged or anything, and that can also affect Luigi Mangione's case in a big way because the juror, and I think it was mentioned in one of Luigi Mangione's court hearings, I think the very first one, the one where Luigi Mangione was wearing a red jumper. Karen Arcafillo also brings that up, and I just thought I should add that here. That was all the way last year in December when they said that. Also, I have written in my notes, the new mayor of New York is really cool. I think he is. I think it's awesome. He's an immigrant, and he's also the mayor of New York. He seems like a pretty cool guy. And Chief Barry Carbone, I think I'm saying that correctly, he is acting as the United States attorney in this case, and basically the judge told him, hey, basically everything what the United States government said, like Donald Trump, other politicians, etc., and outlining what they said can affect Luigi Mangione's case in a big way, and they pointed out that rule to him, saying, hey, this is the rule you guys are breaking. Explain yourselves. So I just thought you should like to know that person's name is. And it's also brought up in the document. Basically, the United States government bluntly ignored the judge's request to explain themselves of why did this happen, and this shouldn't have happened in the first place, and this should not happen again. And we clearly saw in the document the United States government bluntly ignored what the judge said. And it's also brought up in the document, the Attorney General, she is very much entwined in this case because she is the only one who can put the death penalty against someone, and that person is Pam Bondi, and she is very much putting herself in this case. If Pam Bondi never mentioned and wanted to put the death penalty against Luigi Mangione, that would have not been put on Luigi Mangione whatsoever, because they weren't even considering, the prosecutors weren't even considering the death penalty against Luigi Mangione until Pam Bondi mentioned it on live TV and to release a new Instagram page, the death penalty against Luigi Mangione. And that is 100% abuse of power, literally just to freaking announce to put the death penalty against someone literally so casually, because literally they want to launch a Instagram page and get more followers because of it. It is a incredibly scummy thing for them to do, and literally again they weren't considering having the death penalty put against Luigi Mangione until she mentioned that. So very much she is entwining herself into Luigi Mangione's case, and even her workers are also falling underneath that category because they are associated with her as well. And it's also brought up in the document basically what the United States government responded with, what Donald Trump did, what government officials from the White House retweeted, and then also what Pam Bondi did, literally goes against what the judge basically asked them to do, and it 100% did. They bluntly ignored what she asked them to do. If you guys remember, literally when the response came out for when the judge asked them, hey, stop doing this, he got another interview from a person working at the White House saying things about Luigi Mangione without saying alleged or anything. It was fucking infuriating. They don't give a shit. Actually, the day before this document was filed, and a detective basically mentions Luigi Mangione's name when the person who asked him the question was not even asking about Luigi Mangione whatsoever. He was asking about an entirely different case entirely. The detective brings up Luigi Mangione's name for some reason when it's not relating to him whatsoever. Why can't they stop talking about him? They are utterly obsessed with Luigi, aren't we all? But why do they need to bring him up when he's not related to something whatsoever? And it's also brought up in the document on September 2nd, 2025, a new filing of rules were put in place for basically when government officials go on TV and all that, things need to be looked at and approved before they say things, and they also request to have a copy of those new rules. And basically it's also mentioned in the document, everyone who works at the DOJ, they basically fall underneath the same category as lawyers, judges, and all that. So statements said from them will affect people's cases in the long run instead of it just being lawyers, judges, etc. When they say things about someone do actually affect people, and it does fall underneath that category. The prosecutors are saying, no, it doesn't fall underneath the category whatsoever, and when it bluntly does, and them ignoring what the judge asked them to do. Again, I keep bringing that up, but it's very infuriating knowing they just bluntly ignored the judge in there. So it's like, no, we're just going to ignore you and do whatever we want to do. It's fucking infuriating. I found quite interesting that I feel like I need to share with you guys. If you guys remember, like many months ago at this point, I think when I started doing this, rejection of the court's order was meant to be filed on April 25th, 2025, not 6 months later when they did. Again, it's infuriating. I think I brought that up when I first started doing this. Again, that was a while ago at this point. But it is fucking infuriating. They just keep ignoring what the judges and the rules and all that put in place for this kind of stuff not to happen. They're just ignoring and doing whatever. Like literally 6 months later they filed that instead of when they were meant to file it. Basically, it's brought up in the document as well. The prosecutions are saying basically what Donald Trump says about Luigi Mangione and other government officials say about Luigi Mangione in his case does not affect his case whatsoever, just because it's so far away. It won't affect his case. People will forget. No, they fucking won't. It's such bullshit. People remember shit. They don't have 2-second memory slots. People will remember, even if TikTok makes us think we don't, but people will remember this in like 6 months time, okay? It's very infuriating. And I'm actually like super fucking glad this is brought up in the document. Like we have it in writing now. Like I've been saying this entire time as me making these videos. This entire case has been so fucking politicalized this entire fucking time. I've said that multiple times, but I'm so glad they actually have this in writing now, and they basically say, literally they said the government keeps using Luigi Mangione as a pawn for proving a fucking point they want to use him for, that honestly I don't truly know why. Like what fucking point are they making in this? So I'm so glad they have this in writing now. We've all been seeing this since the beginning. I've been saying this since I've been making these videos. This entire case has been so fucking politicalized this entire time, and now they have this in writing. And I'm so fucking glad they have this there, because it 100% has literally been more so about politics than literally what this entire case is about, and it's fucking insane. This bit I found incredibly interesting when I was reading the document, and basically I did not know this, but it makes a lot of sense now. So basically they bring up in the document the reason why they know the United States government won't stop these prejudicial comments towards Luigi Mangione, because literally the Unitedhealthcare, basically they have their hands in the United States government. So basically they know if they make Luigi Mangione look bad, it is benefiting Unitedhealthcare, because literally they have their hands in the United States government. And also around that time Brian Thompson was murdered, they were underneath investigation because of their sketchy Medicare practices. Now if the Unitedhealthcare have their hands in the United States government, they benefit of making Luigi Mangione look bad, because literally it makes people look at him than what the sketchy shit they are doing, if that makes sense. So I thought that was very interesting they bring this up. Like, I did not know this, but I kind of had a feeling, but I'm glad we actually know about it now. So literally the Unitedhealthcare system in America, they have their hands in politics. So So it makes a lot of sense why they will not stop their prejudicial comments towards Luigi Mangione. Something to chew on, and I really wanted to bring that up here. Me saying that as well, I'm gonna go off a little bit from the original document I'm going to be talking about for a minute. There is another document I am going to show you guys that also makes you guys think quite a bit of, like, there's a lot of things, basically people having their hands into this case when it's literally not related to them at all. It's like, that makes a lot of sense. Why? Just thought I should put that there. Basically, at the end of the document, they wrap everything up basically saying this entire case needs to be dismissed just because of how prejudiced this entire case has been ever since the beginning of this case all the way back in December 2024, and they need to dismiss this entire case, or at least get rid of the death penalty that was literally put on Luigi Mangione because Pam Bondi said so. So that I really hope this does happen in the future. Like, they do make some amazing points here that make a lot of fucking sense, and also literally the United States government and also the prosecution just not following the judge's words whatsoever in this document, and also the letter they requested for them to, hey, stop doing this shit, but then government officials, politicians, etc. keep doing this. They are utterly obsessed about Luigi. They don't want to shut up about him. Neither do I. But sometimes I do these fucking jokes and I don't know how to handle my own stupid jokes. That is the reason why they want this entire case to be dismissed, or even just the death penalty be thrown out, just because of how prejudiced this entire case has been that we've all been seeing ever since the fucking beginning. We all know that, I've been saying that, and now it's officially in writing. Now, I can give you some examples just to refresh your mind, because it has been officially a year now since Brian Thompson's murder, and basically, if you guys remember the stage per book, if you guys remember the writing on the bullets, by the way, don't exist. If you guys also remember the old mayor of New York saying a bunch of things about Luigi Mangione without saying a list or anything like that. When Pam Bondi said she wants to put the death penalty against Luigi Mangione, and then also after that, then Donald Trump went on TV and said a bunch of things about Luigi Mangione without saying alleged, and then other politicians retweeting that, and then even at a different conference event, they brought up Luigi Mangione's name and not said alleged or anything like that. And then again with like a Pam Bondi saying things about Luigi Mangione after Donald Trump did his Fox interview. Detective brings up Luigi Mangione's name when the question wasn't even about Luigi Mangione at a conference. And then also there's probably other accounts that I don't remember that have also happened in this case of prejudicial comments towards Luigi Mangione that I clearly don't remember. There's been so many. I made a comment about this many months ago on like a Reddit post of me saying I think Luigi Mangione's legal team is just like collecting every single email people are sending to them of saying, oh hey, they said shit about Luigi Mangione and not said alleged, and this is the document proving they definitely have been. So that's exciting. So literally they're gathering every little piece of information of basically the government doing this and the prosecutors doing this and just having the receipts. So I do recommend doing this, by the way. So if you guys see any tweets from any government officials, people higher up and stuff like that, or interviews, etc., please send it to Luigi Mangione's legal team. It is on his official website. There's a little box thing there and you basically can like send them the link, say, oh hey, this official person said this thing about Luigi Mangione, and they will put it in a document like this. But you do need to remember it will be public, so don't write anything that you don't want the world to see. Have that noted. But yeah, please do that if you do see it, because you know, I live in Australia, I don't always see it, I'm always asleep when it's happening, but this is a really good ass document. So we are now moving on to the next document for you guys. 17th of October 2025. This is a document from Thomas Dickey rejecting the rejection of the second habeas corpus, and Man, saying the rejection of the rejection is like kind of funny to me. From Thomas Dickey. Now, please take this document with a little bit of skepticism. I did get this from Reddit. So I do want to say sorry if you randomly see stars or like highlighting in this document. You can clearly tell it wasn't done by the official person who uploaded the document to wherever Thomas Dickey's stuff goes. I don't know. I said earlier I don't have access to his official website. But you can clearly tell it was like someone else who did that. They must have done it like on a phone or tablet or something like that. I'm not sure, but I do want to apologize about that. I just can't find the document without those things that were shared around. Just want to have that noted. Anyway, I'm going to put that document up on screen for you guys.
Commonwealth of Pennsylvania, v. Luigi Nicholas Mangione, Defendant, Original, in the Court of Common Pleas of Blair County, Pennsylvania, No. CP 07CR0002724-2024. Defendant's response objection to Commonwealth's second notice of the federal government's denial of habeas corpus ad prosequendum motion for reconsideration of order deeming defendant unavailable as a waiver of Rule 600. Filed on behalf of Luigi Nicholas Mangione, Defendant Attorney for Defendant, Thomas M. Dickey, Esquire, Pennsylvania ID 41475, Tom Dickey Law Offices, PC 308 Orchard Avenue, Altoona, Pennsylvania 16602. In the Court of Common Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania, No. CP 07CR0002721-2024, OTNF 1009165-3 var, Luigi Nicholas Mangione. Defendant's response objection to Commonwealth's second notice of the federal government's denial of habeas corpus ad prosequendum motion for reconsideration of order deeming defendant unavailable as a waiver of Rule 600. And now comes Luigi Nicholas Mangione, defendant above named, by and through his attorney, Thomas M. Dickey, Esquire, and files this response to Commonwealth's second notice of the federal government's denial of habeas corpus ad prosequendum, respectfully representing as follows: the Commonwealth had filed on or about October 3, 2025, a second notice of the federal government's denial of habeas corpus ad prosequendum, hereinafter referred to as the second notice. In its second notice, the Commonwealth alleged in F6 that the United States Attorney's Southern District of New York, by a letter dated for February 12, 2025, indicated that defendant Mangione would not be made available to Blair County until the disposition of his federal charges, including any sentencing proceeding. Emphasis added, this letter further indicated that the defendant could only be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. ID, infinitum. The Commonwealth stated in 97 of its second notice that on or about June 20th, 2025, it received defendant Mangione's precept to schedule hearing and demand for personal appearance on or about June 20th, 2025, and thereafter contacted the federal prosecutor's office in New York regarding the demand. After contacting said office, the United States Attorney's Southern District of New York repeated the exact same response to the Commonwealth as it had in 91 of the present filing 18. Nevertheless, this court signed a writ of habeas corpus ad prosequendum on or about September 8, 2025, as indicated in 110 of the Commonwealth's second notice. This writ was denied by United States Attorney's Office for the Southern District of New York data analyst Sheena Wills on September 10, 2025, 411, when this court asked the Commonwealth to procure a memorialization of the denial from said attorney's office. The Commonwealth instead elected to memorialize the denial itself, when data analyst Sheena Wills said over the phone that no further written correspondence would be forthcoming. 912. The Commonwealth's memorialization was in its notice of denial of writ of ad prosequendum, hereinafter referred to as the first notice filed on or about September 17, 2025, as indicated in 112 of its first notice. 4. Only after filing its own memorialization of the denial on behalf of the United States Attorney's Office for the Southern District of New York did the Commonwealth ask the United States Department of Justice for a more formal response over a week later, on September 25, 2025. Second notice, 113. 1 day later, said attorney's office promptly responded via email September 26, 2025 with a letter memorializing the denial of the writ, emphasis added, ID. However, this prompt response was received after close of business Friday, September 26, 2025, ID. This memorialization was not received by this court until Monday, September 29, 2025, after it once again asked the Commonwealth for a more formal response from the United States Department of Justice, this time by outright issuing an order directing the Commonwealth to do so. 114 Cyrillic letter B. After receiving said order, the Commonwealth wrote its second notice, attached the federal memorialization letter, and filed its second notice on October 3, 2025. ID. At the end of its second notice, the Commonwealth asked this court to acknowledge Defendant Mangone's unavailability pursuant to PAR, Crim P600 unless Defendant Mangione elect to appear via video conferencing, ID, at 6. Within the attached federal memorialization letter, United States Attorney for the Southern District of New York Sean S. Buckley wrote that her office will instruct the United States Marshals not to honor any writ seeking to take custody of the defendant to appear in your jurisdiction. Emphasis added. 7. The defendant avers that his right to be present at every critical stage of his prosecution is protected and guaranteed under the Sixth Amendment of both the Constitution of the United States and of this Commonwealth. 8. The Pennsylvania Supreme Court has held that the Pennsylvania Constitution clearly, emphatically and unambiguously requires a face-to-face confrontation. Commonwealth v. Ludwig, 527 PA 472, 478, 594A, 2D 281, 284, 1991. Additionally, Pennsylvania courts have recognized that the Sixth Amendment Confrontation Clause requires that a defendant be given the opportunity to be physically present at trial. Commonwealth U. Walls, 2010 PA Super 54, 116, 993A, 2D 289, 297, PA, Super, CT, 2010, 9. The Supreme Court of the United States has strongly and consistently recognized this very right to be present at every critical stage of trial. In Kentucky v. Stinson, the Supreme Court held thus: the court has assumed that, even in situations where the defendant is not actually confronting witnesses or evidence against him, he has a due process right to be present in his own person. His presence has a relation, reasonably substantial, to the fullness of his opportunity to defend against the charge. Snyder, Massachusetts, 291 U.S. 97, 105 106, 54S, CT 330, 332, 78L, ed. 674, 1934. Although the court has emphasized that this privilege of presence is not guaranteed when presence would be useless, or the benefit that a shadow, ID, at 106 107, 54S, CT, at 332. Due process clearly requires that a defendant be allowed to be present to the extent that a fair and just hearing would be thwarted by his absence, ID, at 108, 54S, CT, at 383. Thus, a defendant is guaranteed the right to be present at any stage of the criminal proceeding that is critical to its outcome if his presence would contribute to the fairness of the procedure. Emphasis added. Kentucky v. Stinson, 482 U.S. 730, 745, 107S, CT 2658, 2667, 96L, ed. 2D 631, 1987, 10. It is neither just nor fair to force the defendant to appear by video, or to not appear at all. The defendant has a due process right to be present in his own person since his presence is substantially related to the fullness of his opportunity to defend against the charge. Emphasis added. Snyder v. Massachusetts, 291 U.S. 97, 105 106, 54S, CT 330, 332, 78L, ed. 674, 1934. The defendant's case is easily one of the most well-known, highly publicized cases in recent memory. His presence not only would contribute to the fairness of the procedure, but is outright necessary for the fairness of the procedure. Kentucky v. Stinson, 482 U.S. 730, 745, 107S, CT 2658, 2667, 96L, ed. 2D 631, 1987, 11. The defendant demands and insists that he be present in person or any and all critical stage proceedings in Pennsylvania and will not agree to waive or diminish in any way his right to be present as protected by both the Constitution of the United States and of this Commonwealth too. Additionally, the defendant has the right to a speedy trial under PAR, Crimp Rule 600, which, without voluntary waiver, can only be considered waived if the defendant is deemed unavailable. 13. Pennsylvania's CASA law makes it clear that incarceration in another state, however, does not automatically constitute unavailability. A defendant is only unavailable if the delay in returning him to Pennsylvania is due to the other state causing the delay. The prosecution, however, must exercise due diligence in attempting to bring the defendant back for trial. Emphasis added. Commonwealth v. Cuban, 432 PA Super 144, 147-48, 637A, 2D 1025, 1026, 27, 1994, citing Commonwealth v. Lloyd, 370 PA Super 65, 80, 536A, 2D 1162, 1160, Alec, denied, 518 PA 637, 542A, 2D 1367, 1988, 14. Due diligence is a concept defined on a case-by-case basis. Commonwealth v. DeMarco, 332 PA Super 316, 325, 481A, 2D 632, 637, 1984. Reasonable effort by the Commonwealth in securing the defendant's presence at trial must be shown to demonstrate that it acted with due diligence. ID, at 323, 636, 15. Although the Commonwealth cannot force another jurisdiction to act, inaction on the Commonwealth's part, without some reliance on the assurances of the other state, does not constitute due diligence. Emphasis added. Commonwealth v. Cuban, 432 PA Super 144, 147-48, 637A, 2D 1025, 1026, 27, 1994. Furthermore, the matters of availability and due diligence must be judged by what was done by the authorities rather than by what was not done. Emphasis added. Commonwealth U. McNear, 2004 PA Super 218, 97, 852A, 2D 401, 406, PA, Super, CT 2004, quoting Commonwealth v. DeMarco, 332 PA Super 316, 481A, 2D 632, 636, 1984, 16. The defendant believes and avers that the Commonwealth, up to this point, has not exercised due diligence in its attempts to make the defendant available in person for all court proceedings. 17. When the Commonwealth was told by data analyst Sheena Wills that no further written correspondence would be forthcoming regarding a federal memorialization of the writ denial, the Commonwealth simply refused to push back whatsoever against this federal inaction. Second notice, 112. Only after the court had to outright order the Commonwealth to push for a more formal response did the Commonwealth do so, which promptly produced a federal memorialization 1 day later. 113, 18. Once again, the Commonwealth has been told by the United States Attorney's Office for the Southern District of New York that it will not cooperate, this time by instructing the United States Marshals not to honor any writ seeking to briefly transport the defendant to Pennsylvania for his infrequent court appearances. Once again, the Commonwealth has refused to push back whatsoever against federal inaction and non-cooperation. The Commonwealth has instead assumed that a second writ would not be honored, just as it assumed that no further written correspondence would be forthcoming regarding a federal memorialization of the writ denial. 112, 19. Additionally, the United States Attorney's Office for the Southern District of New York stated that it will instruct the United States Marshals not to honor any writ seeking to take custody of the defendant to appear in your jurisdiction. Emphasis added. From the plain language of said attorney's office's letter, this instruction to not honour writs is written in a vague and uncertain future tense. Therefore, it is not a definite and present instruction preventing the Commonwealth from taking further present action. 20. Furthermore, the Commonwealth should be required to take all further steps necessary for ensuring the United States Attorney's Office for the Southern District of New York takes any and all action, including but not limited to a. Supplying to the court proof of service of the actual writ for the United States Attorney's Office for the Southern District of New York. 21. The defendant believes and avers that the Commonwealth's attempts in procuring the defendant's presence for trial in Pennsylvania have been, at best, token efforts. The Commonwealth has, up to this point, failed to make the kind of reasonable effort required of it to demonstrate that it acted with due diligence. Commonwealth U. DeMarco, 332 PA Super 316, 323, 481A, 2D 632, 636, 1984. Therefore, the Commonwealth has not exercised due diligence in its attempts to make the defendant available in person for all court proceedings. Wherefore, the defendant prays and requests that this honourable court enter an order, a scheduling a hearing on all motions relative to the defendant's availability and or due diligence efforts made by the Commonwealth, and or be attributing all time periods on the Commonwealth for Rule 600 purposes due to its lack of due diligence for reasons set forth in this motion, and or c. enter an order vacating the order on October 15, 2025 deeming the defendant unavailable as a waiver of Rule 600, and or d. vacating 13 of the order deeming the defendant unavailable as a waiver of Rule 600, and or re-entering any other relief deemed appropriate. Tom Dickey Law Officers, PC Motive Thomas M. Dickey, Requiro Attorney for Defendant. Public Access Policy Certification. I certify that this filing complies with the provisions of the Public Access Policy of the Unified Judicial System of Pennsylvania. Case records of the appellate and trial courts that require filing confidential information and documents differently than non-confidential information and documents. Thomas M. Dickey, Esquire.
On the 3rd of October 2025, prosecutors in Pennsylvania rejected the second habeas corpus, and basically Thomas Dickey is rejecting their rejection of the second habeas corpus. And also on February 12th, 2025, they got informed Luigi Mangione won't be there in person to do the Pennsylvania stuff because, you know, he's busy in New York. And it's very funny in this document, they do bring up literally the Pennsylvania attorneys went and called the New York attorneys and said, hey, can we have Luigi? And they're like, no, he's busy in New York. We can't give him to you. He's busy in New York. So I did find that funny. Like, they were already being told by Luigi Mangione's legal team in Pennsylvania he can't be there in Pennsylvania. And then they just asked higher ups in New York if they can hand him over. And they said, no, he's busy. I thought that was kind of funny. I feel like it would be a lot more serious than how I put it. You guys remember in my last video going over updates on Luigi Mangione's case, there was a data analyst in the Pennsylvania case side of things trying to make actual authority rules about things when she literally has no power or authority to do that whatsoever. She was also brought up again in this document. And yeah, she tried to make these authoritarian rules for this to happen when she has no authority whatsoever compared to a judge or a lawyer in this case. So I found that interesting. She was also brought up again. So Brownie Pikes, if you remember her, by the way. Basically, after they got that response from that data analyst who has no authority whatsoever, they basically officially asked, hey, can we have someone with more authority to actually have this more official? Then they replied to that basically on Friday, past the hours of, like, you know, people are working, and they did not receive that document until literally Monday. Basically, they failed to literally follow instructions and have things before the deadline. And they go further in detail, basically saying it is Luigi Mangione's right to be there in person, that it is for Luigi Mangione to be there in person instead of forcing him to do it virtually. Like we showed earlier, it is covered underneath a rule for Luigi Mangione to do it in person. I don't remember the number, there's too many numbers and words in this documents I've been reading. And it's also brought up in the document literally how publicized this entire case case has been. It definitely has. So it is very important for Luigi Mangione to be there in person because of that reason as well. That is his right to be there, and I'm glad Thomas Dickey and Luigi Mangione, they are not budging on Luigi Mangione doing this virtually. Like we already know, this has been put on pause because Luigi Mangione's availability is not available yet because, you know, he's in New York dealing with the New York charges. Also, it's brought up in the document, basically the prosecutors in Pennsylvania, they have failed and not even tried to send Luigi Mangione to Pennsylvania from New York, and I want to quote this here, token efforts trying to send Luigi Mangione to Pennsylvania. Thought it was kind of funny. I like all these digs these lawyers are giving to each other. They're very formal digs, but I really like them. But it is definitely true. They are not even trying to send Luigi Mangione to Pennsylvania from New York. Again, pulling teeth. Don't be surprised. Okay, so this next document I'm going to show you guys, I found it very interesting, and I feel like it is important to Luigi Mangione's case, instead of like what I do sometimes where I put like things aren't really relevant to his case. I put it near the end of the video, but I feel like this is something very important I want to show you guys. So this document I did come across from Reddit, so take it with a little bit of skepticism. So basically this document is showing a district attorney, Pam Bondi. She was a lobbyist for the Unitedhealthcare, and I found that incredibly interesting. You guys should find that interesting as well. It does add another layer to this entire case internal. So anyway, I'm gonna put this document up on screen for you guys.
15th of January 2025, Pam Bondi's extensive lobbying for wealthy special interests and foreign government poses serious conflict of interest. Pam Bondi is a registered lobbyist with the Washington, D.C. based firm Ballard Partners and has represented wealthy special interests and foreign governments, presenting serious potential conflicts of interest if she is confirmed as Attorney General. When presenting information to the committee, Pam Bondi only listed 2 potential conflicts of interest: her work for America First Policy Institute and her brother's legal practice. Bondi failed to identify every single one of these as potential conflicts of interest. Employment as a partner at Ballard Partners, Bondi did not list her current role as a lobbyist as a potential conflict of interest, nor any of the specific work she's done for her clients that might implicate her role as the chief federal law enforcement officer. She's lobbied on behalf of more than 30 different clients, including corporations like Amazon and Uber, government contractors like private prisons, and the government of Qatar. Lobbying on behalf of private prisons, Bondi lobbied for the Geo Group, a private prison company that has faced criticism for safety violations, providing inadequate health care, and poor management practices. These actions have negatively impacted the welfare and rights of incarcerated individuals and immigration detainees, and the Geo Group stands to earn hundreds of millions of dollars during the Trump administration, as ICE is its largest source of revenue. Lobbying Congress on behalf of Qatar. As a FERA registered lobbyist, Bondi lobbied Congress on behalf of Qatar, earning $115,000 per month. Employment in private practice. Bondi did not list any potential conflicts of interest from her private practice. U.S. Senate Democratic Whip Dick Durbin, DIL, ranking member of the Senate Judiciary Committee, released the following statement: "I'm disappointed that Pam Bondi failed to list several clear conflicts of interest, which indicates she does not take these conflicts seriously. The American people deserve an Attorney General who avoids even the appearance of impropriety, and they deserve an Attorney General who will put them ahead of any wealthy special interest or foreign government." End Citizens United at Stop Big Money. Pam Bondi has been a lobbyist for Amazon, Unitedhealthcare, Uber, and Qatar. Trump picked her because she won't fight for justice, she'll fight for big money special interests. Senate Judiciary Democrats at Judiciary Dems, January 13th. Pam Bondi is a registered lobbyist, including for foreign governments. The committee must be able to review crucial, outstanding information on her lobbying. Basis Monk Diane Inton, 3:42 p.m. January 13th, 2025. Senate Judiciary Democrats at Judiciary Dems. Pam Bondi is a registered lobbyist, including for foreign governments. The committee must be able to review crucial, outstanding information on her lobbying. Dion Dutton, 12:15 p.m., January 13th. Committee on the Judd Carey, Washington, D.C. 20510622751, January 10th, 2025. X7 Turgeon Unit Chief for a Unit National Security Division, U.S., Department of Justice 175 N Street, NE Washington, DC 20002. Dear Mr. Turgeon, I write to request records relevant to the Senate Judiciary Committee's consideration of the nomination of Pamela Jo Bondi, President-elect Trump's presumptive nominee to be Attorney General, from January 2019 through November 2019, and again from January 2020 to present. Ms. Bondi has been a lobbyist with Ballard Partners. In this role, she has acted as a Foreign Agents Registration Act for a registered lobbyist on behalf of several foreign governments or officials, including the government of the Dominican Republic, the Embassy of the State of Qatar, the Minister of Foreign Affairs of the Republic of Zimbabwe, and the Republic of Kosovo. However, Ms. Bondi did not list any of these matters or clients as potential conflicts of interest on her Senate Judiciary questionnaire. To understand the extent to which her work as a FERA registered lobbyist may create potential conflicts of interest should she be confirmed as Attorney General, the committee requires additional information from the Department of Justice that is not otherwise available. As you know, FERA registered lobbyists must produce to the Department of Justice a copy of their written contracts or the conditions of any oral agreements with in principles, as well as statements on activities and money spent and received in connection with FERA-related lobbying. To that end, please provide the following information or registration statements. Ms. Bondi has filed for her work on behalf of any foreign principal or written contracts or conditions of oral agreements. Ms. Bondi has filed for her work on behalf of any foreign principal or statements on activities and money spent and received in connection with lobbying. That Ms. Bondi has filed for her work on behalf of any foreign principal and all information or materials distributed in the United States. That Ms. Bondi has filed for her work on behalf of any foreign principal. Please provide these materials as soon as possible, and no later than January 15, 2025. I appreciate your prompt attention to this important request. Sincerely, Dickey Dawkin Richard J. Durbin Ranking Member CC, Ein Honorable Charles E. Rasselai Chairman, Senate Committee on the Judiciary. Dr. Colleen J. Shogun, Archivist of the United States U.S. National Archives and Records Administration, 700 Pennsylvania Ave, N.W. Washington, D.C. 20480. Dear Dr. Shogun, I write to request records relevant to the Senate Judiciary Committee's consideration of the nomination of Pamela Jo Bondi, President-elect Trump's presumptive nominee to be Attorney General, from January 2019 through November 2019, and again from January 2020 to present. Ms. Bondi has been a lobbyist with Ballard Partners. In this role, she has acted as a Foreign Agents Registration Act for a registered lobbyist on behalf of several foreign governments or officials, including the government of the Dominican Republic, the Embassy of the State of Qatar, the Minister of Foreign Affairs of the Republic of Zimbabwe, and the Republic of Kosovo. Additionally, she has provided lobbying services on behalf of the following organizations: Major County Sheriffs of America, Alden Torch Financial, LLC, American Kitchen Cabinet Alliance, Balsam Brands, Incorporated, Bankers Financial Corporation, Carnival North America LLC, Fidelity National Financial, Incorporated, Florida Sheriff's Association, Florida Sheriff's Risk Management Fund, General Motors LLC, KG Investment Company, KSCC Lenders Consulting Group, LLC, Major League Baseball, NAS Health Pool Capital Partners, LLC, U.S. Institute Against Human Trafficking, IGT Global Solutions, Pulaski Law Firm, PLLC, Uber Technologies, Incorporated, Allison.com, American Road and Transportation Builders Association, Anderson, Kill PC, Kreendler and Kreendler LLP, Children's Hospital Association, Troy International Bridge Company, Incorporated, Republic Services Procurement, Incorporated, Varian Medical Systems, Lathrop Gage LLP. However, Ms. Bondi did not list any of these matters or clients as potential conflicts of interest on her Senate Judiciary questionnaire. To understand the extent to which her work as a lobbyist may create potential conflicts of interest should she be confirmed as Attorney General, the committee requires additional information from the National Archives and Records Administration that is not otherwise available. To that end, please provide the following information: all records between January 1st, 2019 and January 20th, 2021 reflecting or relating to communications between and among White House officials and with any executive branch employee. concerning or including Ms. Bondi, all records between January 1st, 2019 and January 20th, 2021 reflecting or relating to meetings between White House officials and any executive branch employee, concerning or including Ms. Bondi. These records should include purpose and attendees of the meeting, notes or transcriptions from the meetings, and see communications about the meetings appreciates provide the mapped it as on as posit, and no later than January 15th, 2025, one sincerely, CC, Dice Duke and Richard J. Durgan Ranking Member the Honourable Charles E. Grassley Chairman, Senate Committee on the Judiciary.
So basically that was the document talking about Pam Bondi. She was a lobbyist for the Unitedhealthcare. So yeah, you can clearly see the Unitedhealthcare are putting all their hands in all the pies in this. Something to chew on, I just want to put here. Allegedly, don't sue me, but something to chew on. 21st of October 2025. This is a notice of motion written by Karen Ockfellow, so I'll pop it up on screen for you guys.
Supreme Court of the State of New York, County of New York, Part 32X. The People of the State of New York versus Notice of Motion Ind. Number 75657/2024. Luigi Mangione, Defendant. X. Please take notice that, upon the annexed affirmation of Karen Friedman Anafilo, ESQ, affirmed to on October 21st, 2025, upon the indictment and the produced discovery, Defendant Luigi Mangione will move this court for an order finding that the certificate of compliance filed by the District Attorney's Office on September 16, 2025, was insufficient. Dated October 21st, 2025, New York. NY. Respectfully submitted, Anafilo Intrater LLP by Karen Friedman Anafilo, ESQ, Mark Anafilo, ESQ, Jacob Kaplan, ESQ 140 Broadway, Suite 2450 New York, New York 10005. State of New York, County of New York, SS, Karen Friedman Anafilo, an attorney at law duly admitted to practice in the courts of New York State, affirms the following to be true under the penalty of perjury. 1. I am an attorney and of counsel at Anafilo Intrater LLP, a law firm located in New York City, and I am an attorney for Luigi Mangione. I make this affirmation in support of a motion, pursuant to CPL Section 245.50, 4, challenging the Certificate of Compliance, COC, filed by the District Attorney's Office on September 16, 2025, 2. Pursuant to CPL Section 245.50, 1. The District Attorney's Office shall serve a COC when the prosecution has exercised due diligence and acted in good faith in making reasonable inquiries and efforts to obtain and provide the discovery required by Subdivision 1 of Section 245.20 of this article, except for discovery that is lost or destroyed as provided by paragraph B of Subdivision 1 of Section 245.80 of this article, and except for any material or information that is the subject of an order pursuant to Section 245.70 of this article. 3. In filing the COC, the District Attorney's Office shall state the following: after exercising due diligence and making reasonable inquiries and efforts to ascertain the existence of, obtain, and disclose material and information subject to discovery, the prosecution has disclosed and made available all known material and information it has obtained subject to discovery. 4. Here, counsel challenges the COC for the following 3 reasons. First, on page 7 of the COC, the District Attorney's Office lists the contents of Batch 8 of discovery produced on April 25, 2025, which includes subpoena returns, 30 folders, one of the folders contains the search warrant returns from WordPress in a PDF file named WordPress Return, Bates Danny 000177748, as produced by the District Attorney's Office. This file is unreadable. 5. Second, on page 10 of the COC, the District Attorney's Office lists the contents of Batch 10 of discovery produced on July 31, 2025, which includes one PDF file named YE Arrest, Bates Danny 000025117, as produced by the District Attorney's Office. This file is also unreadable. 6. Third, during a December 17, 2024, press conference, the district attorney and the NYPD chief of detectives referenced information that the FBI had received from a sergeant in the San Francisco Police Department relating to a missing person report filed by the Mangione family. According to the NYPD chief of detectives, this information was provided to NYPD officers embedded within FBI Task Force 7. Additionally, as noted in the media, Sergeant Michael Horan from the San Francisco Police Department contacted the FBI after observing a resemblance between the suspect from the New York City incident and the photos on Mr. Mangione's social media. News release. San Francisco Police Department, SVU Sergeant Michael Horan recognized for identifying a high-profile murder suspect 2515, January 30th, 2025, https://www.sanfranciscopolis.org//. Michael Horan recognized identifying high-profile 8 to date. However, the district attorney's office has not produced any information or documentation in discovery related to either the missing person report filed in San Francisco or reports concerning Sergeant Horan's observations. Because the NYPD relied on this information as part of their investigation, these items are subject to discovery under CPL Section 245.201. Consequently, the district attorney's office should have exercised due diligence and acted in good faith in making reasonable inquiries and efforts to obtain these records. See CPL Section 245.501. The prosecution has failed to do so. 9. Because the district attorney's office has not properly produced the WordPress in Hawaii arrest records and has not produced any records relating to the San Francisco reports, this court should find that the district attorney's September 16, 2025, copy was insufficient. Dated October 21, 2025, New York. NY respectfully submitted, Karen Friedman, Anafilo, Mark Anafilo, Jacob Kaplan, counsel for Luigi Mangione.
In this document, they go over basically saying the document, the certificate of compliance by the prosecutors, basically handing over all the evidence they have against Luigi Mangione, and they send it to his legal team so they can have a look at it all. It was basically inefficient. That was sent on the 16th of September 2025, and I will go over the documents that were making this incomplete. These are the 3 reasons why this document is inefficient. Basically, what they gave to the Luigi Mangione's legal team, these documents do not work whatsoever, and also there's other documents they did not send to Luigi Mangione's legal team that are meant to be in this document. So this first document was called, and the official file name is called Denny 00017748. So basically in the document it does say unreadable. That basically means the document is corrupted and you can't open it or read it or whatsoever. I thought I should put that here. Basically that's what it means. But that is the first reason why this document is inefficient, because literally one of the documents they can't access whatsoever because it is corrupted. On page 10 of the document of discovery, a document that was filed on the 31st of July 2025, it was basically corrupted and no one could access it, no one could see it. This document was called Discovery Produced. That was filed on July 31st, 2025, and this document was called Denny 0025117. That was what the document was called, and it was corrupted and no one could see it because it was unreadable. They also bring up in the document another piece of evidence and information they did not receive whatsoever. So on December 17th, 2024, a NYPD chief or detective basically went on News Network and basically said they have information from a missing person report from Luigi Mangione's family, and basically they handed that paperwork off to prosecutors and also the Pennsylvania police force and also in New York, but they never handed that information over to Luigi Mangione's legal team whatsoever with that information. That's another reason why this document is inefficient, because I have that information. And basically what the prosecutors handed over as the document of compliance it is inefficient because literally some of the documents they handed over is corrupted and no one can have access to it because, it doesn't work. And then also, they did not hand over every single itty-bitty piece of information and evidence to Luigi Mangione's legal team when they absolutely should. This is another document from Thomas Dickey, basically rejecting the rejection of the Habeas Corpus. Please take this document with a little bit of skepticism. I did get this from Instagram, so I'll pop it up on the screen for you guys.
17th of October 2025 Dickey, Thomas M. Defendant's response to Commonwealth's second notice of denial of habeas corpus ad prosequendum Blair County District Attorney's Office the 21st of October 2025 e-service served.
My throat is hurting, man. How do people do this for long periods of time? How do podcasts do this? The 22nd of October 2025. This document was going to be pretty similar to the document I showed you earlier, where it wasn't really relevant to his case, but I felt like it was very important in Luigi Mangione's case, of like when Pam Bondi was a lobbyist for Unitedhealthcare, but sadly I did not take screenshots. I should have taken screenshots of this. Sadly the Reddit post has been deleted, and I did use the Wayback Machine and I can't find the original post anywhere, sadly, but I do want to note this here. This original document basically had all the misconduct and all the bad things the police who arrested Luigi Mangione, and I thought it was very important to show you guys, but sadly it doesn't exist anymore, but I thought it was useful information to have here. But also take that with a little bit of skepticism because I got that from Reddit as well. But I thought it was important anyway. Basically around this time as well, there were a lot of people coming out saying they knew Luigi Mangione when they clearly didn't, or that guy who went on TV and said a bunch of things about Luigi Mangione that was 100% cloud chasing, and then there were people that were coming out saying they know Luigi when they didn't. I wasn't going to talk about that whatsoever, but then I was going to have a lot of notes about it in this, talking about it, and then I just decided to make a full-ass video about it. I came back with that video with like a vengeance. I was so pissed and incredibly sarcastic in that video. I'm normally not like that. I was just really mad. And apparently that video was popular. Normally I'm not that pissed all the time, guys. I'm pretty chill, I think, anyway. Anyway, I was gonna have like little notes about that in this and just say, hey, stop believing everything you see about Luigi Mangione's case unless it's from like official sources from his legal team. But then I decided to make a full video about it. Anyway, so that basically was going on quite a bit at the end of October and majority of November. And sadly, when we don't really hear much from Luigi Mangione's legal team, sadly a lot of that kind of stuff runs wild. I mentioned that in that video, but I'm gonna put this here. People need to stop taking things at face value if it's not from Luigi Mangione's legal team or from official sources and running with it, because literally people just need to have some literal thinking skills. Like, in life in general, I'm noticing that a lot more, and that's kind of dangerous. People need to like keep having literal thinking skills and look into things more instead of just scrolling twice and just going, yep, that's enough research, this is fact, this fits my agenda. But again, I made a whole video about that. Go check it out if you want to. Just disprove basically everything what those people say in that video, because people need to talk about the disproving of the bullshit those people were saying. Anyway, we're moving on. The 12th of November 2025. This moment in time, we didn't really hear much from Luigi Mangione's team. Like I mentioned before, for a while I thought it was no news was good news and have a document from Karen Arcafillo, so I'll pop it up on screen for you guys.
Supreme Court of the State of New York, County of New York. Part 32 volts The people of the State of New York v. Luigi Mangione. Reply affirmation is in support of motion IND. Number 75657/2024. Defendant. State of New York, County of New York. S. Karen Friedman Anafillo, an attorney at law duly admitted to practice in the courts of New York State, affirms the following to be true under the penalty of perjury. I am an attorney and of counsel at Anafillo Intrator LLP, a law firm located in New York City, and I am an attorney for Luigi Mangione. I make this reply affirmation in further support of a Mr. Mangione's October 21st, 2025, motion, pursuant to CPL Section 245.504, challenging the Certificate of Compliance, COC, filed by the District Attorney's Office on September 16, 2025, 2. As part of Council's October 21, 2025, motion to invalidate, we noted several issues with the COC, that 2 files were provided in an unreadable format, and that the people had not provided information or documentation related to a missing person report filed by the Mangione family in San Francisco. In their response, the prosecution acknowledged that 2 of the files they had provided in discovery were not readable because of a processing error, and that they were going to reproduce these files. The files have since been reproduced. 3. As to the San Francisco paperwork, the people claimed that it had previously provided this information in discovery. As noted below, however, there is a key component of the San Francisco investigation that the people have failed to provide discovery on. 4. In a December 17, 2024, press conference, the district attorney and the NYPD chief of detectives referenced information that the FBI had received from a sergeant in the San Francisco Police Department relating to a missing person report filed by the Mangione family. According to the NYPD chief of detectives, this information was provided to NYPD officers embedded within an FBI task force. The following is the transcript of the relevant portion of the press conference. The original missing report took place back in November 18 in San Francisco. The sergeant that was involved in the case reached out to the San Francisco field office and said, "Hey, basically I'm working on a missing case. I saw a photograph that was distributed by the NYPD. There bears a resemblance." That tip was forwarded to us close to 45 hours after the incident took place. It showed up to a TFO, which is a task force officer. We have NYPD officers embedded with the FBI. They received that tip. It was one of 4 tips they received that day and they were vetting it. Part of that vetting process was that they reached out to Mangones. We appreciate the people's claim that it is understandable how the defense could have missed the material regarding the San Francisco missing person report and Sergeant Horan's outreach to the FBI. People's response at 5. Given the sheer volume of discovery, more than 7 terabytes processing through all the materials has been painstaking and time-consuming. Complicating matters is the fact that Mr. Mangione still has not had the opportunity to review all the voluminous discovery. Although the federal court has previously issued a laptop order, there is a lengthy and laborious process that must be completed before Mr. Mangione receives the laptop at the MDC. The laptop must first be purchased and sent to an approved IT vendor who disables the laptop's connections to the internet, printers and wireless networks in compliance with the MDC's regulations. Once this process is finished, which takes many weeks to complete, the laptop is then provided to the government so that all the non-sensitive discovery can be uploaded before the laptop is sent to the MDC. In this case, the first 2 steps have been completed, and the government is currently loading portions of the discovery on the laptop. Once this process is completed, the government will deliver the laptop to the MDC for Mr. Mangione to review. We note that the process is more complicated in this case because the 7 terabytes of discovery do not all fit on the laptop. Consequently, Council and the government will have to coordinate to provide Mr. Mangione with a hard drive that contains the remaining discovery that does not fit on the laptop. Once Mr. Mangione receives the laptop and hard drive, he will need time to meaningfully review the discovery, including voluminous body camera footage, in time for December 1, 2025, hearings. San Francisco very late on the 7H. They had a conversation where she didn't indicate that it was her son in the photograph, but she said it might be something that she could see him doing, so that information was going to be passed along to the detectives the next morning, but fortunately we apprehended, emphasis added 5. According to this statement by the NYPD chief of detectives, Luigi Mangione's mother stated that December 4, 2024, shooting might be something she could see him doing. This statement was then widely quoted by numerous news outlets, including the following. Date outlet excerpt URL. The 17th of December 2024 Fox News. They had a conversation where she didn't indicate that it was her son in the photograph, but she said it might be something that she could see him doing. The 18th of December 2024 People. They had a conversation where she didn't indicate that it was her son, but she said it might be something that she could see him doing. 8,763,407. The 17th of December 2024 Yahoo News. Luigi Mangione's mum told cops, the UHC shooting might be something that she could see him doing. The 17th of December 2024 Newsweek, they had a conversation where she didn't indicate that it was her son, but she said it may be something she can see him doing. The 1st of April 2025 CBS News, speaking to reporters, Kenny said his mother told an FBI task force that the shooting might be something that she could see him doing. The chief of detectives' unfounded claim continues to be cited, as it was recently repeated in a Reckless novel that was published on November 4th, 2025. His mum reported him missing on November 18th, 16 days before the shooting. She reported him missing in San Francisco because she thought that's where he lived. When the police questioned her about the shooting, she said she could see Luigi doing something like that. At least that's what NYPD Chief of Detectives Joseph Kenny told the media. John H. Richardson, Luigi, The Making and the Meaning 9-3, 2025. This book, which is riddled with verifiable factual errors and false assumptions about Mr. Mangione, repeats the Chief of Detectives' claim as it was a verified fact. 7. To date, there has been no documentation provided in discovery that confirms the Chief of Detectives' statement as to Mrs. Mangione's alleged statement. In fact, all the discovery provided so far indicates that she did not make such a statement. Consequently, there are only two possibilities. 1. That Mrs. Mangione never made this statement and that the Chief of Detectives purposefully provided false information to prejudice Mr. Mangione's ability to receive a fair trial. If it is true that Mrs. Mangione never made this statement, then it is shocking and unconscionable that the District Attorney's Office and the NYPD have never corrected this highly prejudicial false statement. 8. The second possibility is that Mrs. Mangione made this statement but, for some unexplained reason, the District Attorney's Office has failed to provide this statement to counsel as part of its discovery obligations. This failure would itself demonstrate that People's Cock is not valid. We ask that the court direct the District Attorney's Office to state for the record whether Mrs. Mangione made this statement to law enforcement. If the statement was not in fact made, counsel will seek additional remedies from the court. 9. Lastly, the prosecution claims in their response that counsel's issues with the cock could have been resolved with a phone call or email to the District Attorney's Office addressing our concerns. Unfortunately, the lead prosecutor made clear back in April 2025 that he would not communicate with counsel via the phone and requested that counsel address inquiries in writing. Even when counsel addressed inquiries via email, such as when counsel could review the property in this case, the District Attorney's Office ignored counsel's emailed requests for months. That is why counsel addressed its cock issues by filing October 21st, 2025, motion with the court challenging the validity of the cock. 10. For these reasons, as well as the reasons argued in counsel's October 21st, 2025, motion, this court should find that the District Attorney's September 16, 2025, cock was insufficient. Dated November 11, 2025, New York. NY. Respectfully submitted, Karen Friedman, Anafilo, Mark Anafilo, Jacob Kaplan, counsel for Luigi Mangione CC, ADA, Joel Sederman, via email, ADA, Kristen Bailey, via email, ADA, Zachary Kaplan, via email, Z. Since filing its cock, the District Attorney's Office has provided 2 additional tranches of discovery, one on November 6, 2025, and another on November 10, 2025. November 6th tranche includes discovery, including body-worn camera footage, that the District Attorney's Office received months before the cock. The District Attorney's Office has informed counsel that the prosecution intends to file a supplemental cock this week explaining the reasons for the disclosures made after September 16, 2025, cock.
Basically, in this document, it's basically requesting to show actual proof of what Luigi Mangione's mum said all the way back in December last year. If you guys remember, these words were floating around at the time, where basically, allegedly, Luigi Mangione's mum said, oh, she sees Luigi Mangione doing that, but I'm pretty sure when we all heard those words, assuming if they were from her, we all kind of assumed it was like the hostel thing, not the actual other thing. We all assumed that at the time anyway, and also now, and this document is just asking for proof for saying, did she actually say this to detectives? And again, we all know the media loves to twist things, especially in this case. So if Luigi Mangione's mom actually did say that, we all know they love to twist words, or did they just make shit up because, you know, big viral case, we need something to tell people. So because those words can be very incriminating. I don't think his mom actually said that. I think it was just shit they made up. Again, it's nothing new. They make up shit all the time. So yeah, basically this document is just asking for proof for seeing if Luigi Mangione's mom actually said that. I honestly think it's absolutely fucking disgusting now. They're bringing Luigi Mangione's family into this compared to beforehand. Like, they're literally trying everything and anything to, like, take Luigi Mangione down. Now they're dragging his family into this, and that's absolutely fucking disgusting, I think anyway. Hi, it's voice over me. So I totally forgot to add this when I was recording this video, but I did have this in my last video talking about this briefly, but it's also brought up in the document. Luigi Mangione still does not have the laptop that he requires to have to look at all the evidence the prosecutors and police have against Luigi Mangione, and they also need to provide a hard drive as well, because not everything can fit on the laptop, and it's honestly infuriating. Luigi Mangione still does not have the laptop when we all thought he did for a good couple of months, but this shows they still have not provided him a laptop, and it's been months at this point when he was granted the laptop. 13th of November 2025. This is just a screenshot of sealed documents from the prosecutors that have uploaded. I don't have access to these documents, but I just thought I should note this here, so I'll pop it up on screen for you guys for a hot minute.
November 13th, 2025 sealed document placed in vault. Just entered. The 13th of November 2025 main document.
The 18th of November 2025, this is a document from Luigi Mangione's legal team requesting for Luigi Mangione to wear court approval clothing to court. Like we've seen, it has been approved, and he looks very handsome, I think, anyway. But I'll put the document up on screen for you guys.
November 18th, 2025 via ECF and email, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York 10007 Re, United States vs. Mangione, 25 CR 176, MMG, Dear Judge Garnett, on September 16, 2025, the Honorable Gregory Caro scheduled suppression hearings in Mr. Mangone's concurrent state case for December 1st, 2025. These hearings are expected to last several days. Mr. Mangione, inmate register 52503-511, is currently housed in the Metropolitan Detention Center, MDC, in Brooklyn and does not have civilian clothes to wear for the hearings. We therefore request, without objection from Judge Caro or the government, that this court order the Bureau of Prisons and the MDC to accept the following hearing clothing for Mr. Mangione: 2 suits, 3 shirts, 3 sweaters, 3 pairs of pants, 5 pairs of socks, and 1 pair of shoes without laces. For convenience, we have attached a proposed order for the court. Respectfully submitted, Karen Friedman, Anafilo Intrator LLP, 140 Broadway, Suite 2450, New York, New York 10005 CC. All counsel, by ECF.
The 19th of November 2025, the request for Luigi Mangione to wear court approval clothing in his December hearings has been approved, so Luigi Mangione is allowed to wear court approval clothing in court, and it does sound like a little funny thing for them to request, but we've seen it in the past. Prosecutors like to humiliate Luigi Mangione by literally letting him wear his prison uniform to his hearings and having him chained and showing him off, saying, look how bad this person is, but compared to letting him look nice. And like we all know, like we've all seen over the last couple of days, Luigi Mangione has been wearing court approval clothing. He looks very handsome, I think, anyway. He looks very nice in his suits. Also, do you guys also think like this? Like, I think calling a man handsome is like equivalent of like calling a girl pretty. I think so anyway. Is it just me? Do you guys think that too? And also, on the same day as Luigi Mangione was granted to wear court approval clothing, the prosecutors submitted a document saying, hey, can we submit a 120-page motion? We all know it was more than 120 pages. I know. This document also came out on the same day. I'll put it up on the screen for you guys.
November 19th, 2025 request granted. The Clerk of Court is respectfully directed to terminate DKT, number 69, so ordered. Dated, November 19th, 2025 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York, 10007 Re, United States vs. Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government writes to respectfully request permission to file an oversized brief in response to the defendant's pending motions. As the court is aware, on September 18, 2025, the defendant sought, and received, permission to file an oversized brief in support of his motion challenging the constitutionality of the death penalty, DKT, number 49. Subsequently, on October 9, 2025, the defendant again moved for, and was granted, leave to file an oversized brief in connection with his motion to dismiss counts 3 and 4 and to suppress evidence and statements. DKT, number 57. In light of the scope and breadth of the defendant's multiple filings, the court granted the government permission to file a single consolidated response addressing all of the defendant's arguments. The filing deadline for the government's brief is Friday, November 21st, 2025. Given the number, complexity, and length of the issues raised across the defendant's submissions, the government's omnibus response will necessarily exceed the court's ordinary limits of 8,750 words and 25 pages. Accordingly, the government respectfully requests leave to file an oversized omnibus opposition brief, consisting of up to 120 pages. Defense counsel does not object to the respectfully submitted Sean's Buckley, attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 Perez/Dominic A. Gentile, June Zhang, Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys, 212, 637, 2,200 government's request.
The 21st of November 2025, this is the day when the prosecution released their 20-plus page motion. You guys already know I made a full audio version of the document, so you guys don't have to like read that full document. And I was very mad they like filed every single extra document, not in the actual motion itself, but they had it separately. Karen knows how to write a motion. She knows to include the extra things in the motion, and then also add the extra documents later. I'm still mad about that. So that's why I'm saying it is 20 plus pages. I'm just gonna go break down the motion for you guys so to understand and rage with me, like I did at the start of the video when I went over my notes, breaking down the document, what the prosecution's written in their 20 plus page motion. Basically, this document is in 3 separate parts. So basically the first part they go over is basically arguing the death penalty should be kept on Luigi Mangione, and then the second part is them arguing this case has not been over politicalized in this entire case. It's bullshit, I might add. The third part of the document is them arguing the evidence and the statements from Luigi Mangione should not be thrown out because Luigi Mangione's backpack, in their eyes, was not illegally searched by police. I do want to add this here. Luigi Mangione's backpack was searched multiple times without a search warrant. I do want to keep adding that. I keep mentioning that. Basically, the death penalty part of the document, basically they are arguing in the document the choice to put the death penalty against Luigi Mangione was not influenced by Pam Bondi whatsoever. They basically argue the death penalty pushed against Luigi Mangione was not influenced by Pam Bondi whatsoever, when it absolutely fucking was. Like we already know, they weren't even considering that as an option until Pam Bondi brought it up. Again, I'm like arguing with my own notes here, but it is very true. They did not consider that to be an option until Pam Bondi announced it, and they saying, no, we decided this on our own. Pam Bondi did not influence us whatsoever. No. And that's basically the entire bit in the entire document of them arguing about the death penalty. It's basically that, but with more words. It went for way longer than expected. Like, literally, they kept adding words to this document, and I wanted to roll my eyes so hard. It was very much like a university student trying to get the word count so they could submit their essay in time. A talking experience. Anyway, that was very much what it was coming across. Like, they kept going and going. They like kept waffling on. Like, you know, when you try to fill the space when there's silence, that's what it very much came off like. And oh my god, I wanted to roll my eyes so hard. And the statements they were making in the document to have the death penalty put on Luigi Mangione was very much bare bones and made no sense whatsoever. It's like, yes, this is the reason why we should have this, when in reality, it wasn't. I wanted to roll my eyes so hard. Now, I was talking to something about this, and I heard this saying from someone. Thank you for telling me this, and this is 100% what this document was. Writing motions with crayons. Thank you for that person telling me that saying. That's 100% what this document is, especially with this death penalty thing. They are trying to say, yes, we should keep this. Only in these bits I meant to break down, but it's very much just them just waffling on and just saying, yes, we should do this. And they also bring up in the document as well the statements from Donald Trump and also Pam Bondi, and the people working in the White House retweeting what Donald Trump said won't affect Luigi Mangione's case whatsoever, just because it's going to happen in the future and people aren't going to pay attention and relate to what they said about Luigi Mangione to Luigi Mangione in the future. And really, that makes no fucking sense. People remember shit, surprisingly. Like, what the hell? In reality, the statements from Pam Bondi and Donald Trump and all the other politicians and what they say about Luigi Mangione will affect Luigi Mangione's case in a big way, because again, it will make him have a unfair jury selection and make it incredibly biased. Also talk about the perp walk was not a political thing whatsoever. That was just something that happened. It wasn't our doing. That's what they're saying. So here's my question. Why was the fucking mayor of New York there at the perp walk last year? Why was the old mayor there? That's my question. Answer me, prosecutors. Oh, that would be really scary if they did. Please don't answer me, I'm scared. And they basically argue in the document they should not throw out the indictment against Luigi Mangione. And basically they say in the document, when Luigi Mangione was being indicted was very much not influenced whatsoever. That's an absolute fucking lie, by the way. Here's my question. How can a film student who studied in a pandemic can see all the holes in your story? That's my question. I'm not even a law student, but I can see it. That's my question. He stops mentioning I studied film and television, but I feel like it makes a really good point as a person who never studied law can understand how much they're fucking up. And they also argue in the document the death penalty pushed against Luigi Mangione was not violating his rights whatsoever. It was. They argue in the document they followed everything by the book. They have the death penalty put on Luigi Mangione so they didn't have to follow the normal protocol, like taking years to push the death penalty on someone like it's normally meant to, and interviewing people. They followed the proper protocols, and they did not break any laws when they were doing it as well. That's what the prosecution says. Honestly, if this document was more written, more like factually, and more like less of like children covering up their own asses, I would take this document more seriously. But I am not. But honestly, aren't we surprised every response from the prosecutors have been like that? Now, on the second part of the document, they go over in a lot of detail about the stalking charges they are pushing against Luigi Mangione, like, way too much. Like, they go into so much detail, like, we get it, okay? You could have stopped about 6 pages ago, but no. Oh my god, like, they kept going, and going, And yeah, it's like, we get it. But basically, in this part of the document, they go over the reasons why they have these stalking charges against Luigi Mangione. I probably should have done a trigger warning. Trigger warning! Suicidal talk mentioned here. And then they went on a little bit of a tangent about self-harm and stuff like that. It was a little bit weird. And they did very much heavily imply Luigi Mangione was suicidal. They didn't directly say he is suicidal, but reading the document, I could very much tell they were heavily implying that, when there was no indication whatsoever Luigi Mangione was suicidal whatsoever. Now, if you guys remember, a couple of weeks ago, I didn't really pay attention to this on Reddit, but it did pop up on Reddit. People were like circling around, thinking Luigi Mangione was suicidal. Did not pay attention to that whatsoever, because, you know, I don't really pay attention to the online drama and gossip and all that. I'm surprised I paid attention to the grifter shit and all that. I literally figured out when I was reading that part of the document, it's like, oh, that's where they got it from. Basically, the prosecutors are very much heavily implying Luigi Mangione was suicidal, when in reality he was not, that we know of. So again, I think it was a very scummy thing for them to do that, to heavily imply Luigi Mangione could have been suicidal. I hate when people do that. They basically villainize suicidal and stuff like that. It's very fucking disgusting stuff, I think, and I kind of hate that people do that, especially with serious things like suicide. And also, same thing with therapy talk, I think that's what it's called, but basically because, you know, people learning all these new words and mental health and all that, it's great we're talking about it, but it's kind of disgusting of horrible, mean people out there are using those words and basically just using them against other people. It's disgusting. I literally have in my notes, what? ... question mark, where are they going with this? In my notes. I'm not joking, they did go on a weird tangent about self-harm for a while, and I have no idea why. It was a little bit weird, they went for a while. I think that was the reaction to arguing the brief mention of when Karen Arcafillo talked about in her motion, basically saying someone could be another reason may put on someone because they're threatening someone they'll hurt themselves if they say won't go out with them. I'm gonna use the notebook, it's a good example. The notebook scene, that's a good example of that, where that was talked about briefly in Karen Arcafillo's motion of maybe that could be considered as a stalking charge. But again, it was very brief, it wasn't really relating to Luigi Mangione's case whatsoever. But then here they ran wild with that. So now we are going into the third part of the motion, basically where they're going to be arguing about they should definitely keep all the evidence they found on Luigi Mangione allegedly, when basically they argue, no, Luigi Mangione's backpack wasn't searched illegally. No, it definitely was, guys. And also in this part of the document, they talk about Luigi Mangione's arrest, and it was fucking hilarious. It was very much them looking at it with rose-tinted glasses. I do want to add that here. It very much was. And it was really funny to read. It's no, he kindly asked Luigi Mangione to stand up. He asked him as a favor. And they also bring up in the document basically arguing Luigi Mangione's backpack was not searched illegally, and the reason why the backpack was searched illegally without a search warrant is because they were afraid they were going to find any weapons, or basically, and they argue in the document basically when Luigi Mangione was searched illegally, I might add, they were going to find the stuff eventually once they got to the police station anyway, once they had the search warrant, so it doesn't matter if they found it at the McDonald's without a search warrant and the camera wasn't turned off when it was driven to the police station, and also searched multiple times without a search warrant once it got to the police station. All of that was going to be found anyway once it got to the police station and they had a search warrant. That's what the prosecution claims. It was going to be there when they got the search warrant, so it was totally fine for them to search the backpack multiple times without a search warrant. That's what the prosecution says. Hope you can hear the sarcasm in my voice, by the way. Also, I do want to keep adding this here. We do not know what happened when that camera was turned off in that police car when his backpack transported from the McDonald's to the police station. We do not know. The body cam was turned off. We do not know what happened in that time frame. We also do not know what happened in that time frame these several hours later. They did not have a search warrant to search his backpack when he was searched multiple times without a search warrant. In the time frame of how many times Luigi Mangione's backpack was searched at the police station without a search warrant, that also happened multiple times as well. Again, we do not know. That time frame is gone. We do not know. It does not exist. And anything could have happened in those missing hours. So now I'm going to be going over when Luigi Mangione was arrested in the motion. You can very much tell in this part of the document, it was very much like written as sunshine, rainbows, rose-tinted glasses. I really hope you can tell the sarcasm in my voice. I literally wrote that in my notes. I think I was very much intending I was going to be incredibly sarcastic in this part of the document. Again, like I mentioned earlier, if they've written this document with any serious things that made sense, I would take it more seriously. Actually written it, I'm so scared they're gonna sue me. So they go over in the document, basically, if you remember in Karen Rockefeller's motion, basically they talked down to Luigi. They were very rude, very demanding towards Luigi Mangione, and then in this part of the document they very much go, oh, the officer politely asked Luigi Mangione, can you stand up? And then he politely told him to sit down, and then he politely asked Luigi Mangione to move his backpack to the table away from Luigi Mangione, just incredibly politely, with so much politeness. And they also bring up in the document the time frame between Luigi Mangione was read his Miranda rights and Luigi Mangione was officially arrested. The time frame was a lot more smaller. And like the example of the time frame they were giving, it is very much very short. Like example, they said, oh, this happened at 9:30, this happened at 9:47, this happened at 9:48. Like the time frame is very short compared to like what we actually have seen. Again, it was very much rose-tinted glasses this entire arrest through the prosecution's eyes. This document was very much written by crayons, like by children. I love that saying. I'm stealing that. Thank you for that person who told me what that means. It made me laugh and I'm gonna use it. So literally this is the first time we've heard about this whatsoever. So they bring up the reason why they frisked down Luigi Mangione multiple times. It's literally because apparently Luigi Mangione mentioned he had a pocket knife in one of his pockets. And I do want to add this here. If he did, we would have heard about this multiple times from the press, from Luigi Mangione's legal team, from prosecution themselves. Literally, it has never been mentioned whatsoever there was a pocket knife in Luigi Mangione's pocket. Now, I do want to add that here. The only time we've heard about a pocket knife in this entire case was literally from one of the police officers opening something in Luigi Mangione's bag at the McDonald's. So that was the reason why they patted down Luigi Mangione multiple times. The pocket knife was never mentioned ever until this moment in time. This entire this entire document is written with like rose-tinted glasses. And they also bring up in the document the reason why they moved the backpack so far away from Luigi, so Luigi Mangione could not reach to his backpack and grab a weapon. That's why they moved it so far away from Luigi Mangione. Okay. Go over the murder of Brian Thompson in the document, and then they're trying to link a bomb to it for some reason, and that's why they were like thinking that's why they had to search his backpack, because they thought there was a bomb in it. Again, it doesn't make any goddamn sense whatsoever, like her covering up her back, saying the reason why she like searched through Luigi Mangione's backpack because she literally thought there was a bomb in it. Again, put two brain cells together, it makes no fucking sense. So in the document, they made a incredibly snarky comment in the document, basically saying Miranda rights are for people that don't give people false IDs. What the fuck? It was incredibly snarky for them to say that in the document. Like, no, Miranda rights are for everyone, even people that hand over fake IDs. Like, what the fuck? So, those are like my final notes of basically what was in the prosecution's motion. Again, it was a lot of me just doing sarcastic comments and commentary on that. But again, like I mentioned, if they'd written it more seriously, I would have taken it more seriously. And literally a lot of it was just basically them waffling on and trying to have a word count. Someone mentioned to me they felt like they were just trying to like do what Karen Ocafillo does, like when she has really long motions, but a lot of that stuff makes sense and it's necessary compared to like what the prosecution were doing, where literally just them keep writing words so they can get a word count so they can be as equal as Karen Ocafillo's motions, my opinion anyway. But I kind of felt like that was going on, and a lot of it was just them waffling on in the motion itself, if that makes sense. So yeah, sorry there wasn't much breakdown. Again, a lot of it was just them waffling on. The 25th of November 2025. This is a document from Karen Ocafillo. Pop it up on screen for you guys.
Via hand delivery, Hon Gregory Caro Anafilo Intra to Supreme Court of the State of New York, 100 Center Street, New York. New York 10001 Re. People vs. Mangione, Ind. Number 75657, 24. Dear Judge Caro, November 25th, 2025 C. We write to the court to resolve several matters in advance of Monday's suppression hearings so that the proceedings may move forward efficiently and without unnecessary delay. As discussed below, Mr. Mangione respectfully requests that the court preclude the prosecution from introducing into evidence the contents of the red notebook allegedly recovered from his backpack on December 9th, 2024, along with the contents of 2 notes and any other writings from the backpack, his person, or any other container. We further request an offer of proof regarding certain witnesses the prosecution has indicated it intends to call at the hearing, as well as clarification on the additional matters set forth below. Background: Mr. Mangione moved on April 30th, 2025, to suppress items alleged to have been in his possession at the time of his arrest, along with numerous statements the prosecution intends to introduce during its case in chief, and requested Mapp, Huntley, and Mosley hearings. The prosecution consented to Mapp and Huntley, and the court granted all 3. The prosecution has since taken the position that the Mosley hearing is premature because they are unsure of their trial strategy. Accordingly, we expect that only the Mapp and Huntley hearings will proceed on December 1st, 2025. Limitations on evidence at the Mapp hearing: the defense has inspected the property that is the subject of the Mapp hearing, including several writings the prosecution alleges were recovered from the backpack that we contend was searched in violation of Mr. Mangione's Fourth Amendment rights. We ask that the court bar the prosecution from introducing the contents of the notebook or any writings into evidence at the hearing, as doing so would make their contents public and would irreparably prejudice Mr. Mangione at his multiple upcoming trials. The prosecution should be limited to using photographs of the exterior of the notebook and other writings that do not reveal their contents. For purposes of a Mapp hearing, the prosecution will not be prejudiced. Its burden is only to prove that the Altoona Police Department acted lawfully under New York law when it seized property without a warrant. The actual content of the writings are irrelevant to that inquiry. Hon Gregory Caro, November 25th, 2025. We further request that witnesses not be permitted to testify regarding the contents of the writings or characterize them in any way, including referring to any item as a manifesto, a prejudicial, invented law, enforcement label. There is no prejudice to the prosecution from these limitations, but the prejudice to Mr. Mangione would be profound. As the court is aware, this case has drawn unprecedented media attention. Any statement, document, or allegation, true or not, is rapidly disseminated by traditional media, social media, and law enforcement sources. If the contents of these writings become public, they are virtually certain to reach potential jurors in this and in the parallel federal prosecution, including prospective federal jurors who will ultimately decide whether to impose the death penalty. Moreover, as detailed at length in our suppression motion, we have made a good faith showing that this warrantless search violated the Fourth Amendment. If the writings are publicly revealed at the hearing but ultimately suppressed, the harm cannot be undone. The prejudice would be insurmountable at both the state and federal levels, where the stakes for Mr. Mangione could not be higher. The defense's proposal is a reasonable and narrowly tailored compromise. It allows the prosecution to meet its burden while avoiding the transformation of a limited suppression hearing into a public mini-trial that would severely prejudice Mr. Mangione. Witnesses for the hearings on January 7, 2025, the District Attorney's Office served counsel with CPL Section 710.30, a notice listing 35 statements attributable to Mr. Mangione. In preparation for the Huntley hearing, counsel noticed that there are more than 10 statements in the Section 710.30 notice that did not have a corresponding witness on the District Attorney's witness list. On Saturday, November 22, 2025, counsel emailed the prosecution to determine whether there were statements in the Section 710.30 notice that the District Attorney's Office would no longer be offering at trial. The District Attorney has not responded to counsel's email. Accordingly, we respectfully request that this court direct the District Attorney's Office to inform the court and counsel whether there are any statements in the CPL Section 710.30 notice that the District Attorney's Office no longer intends to be the subject of the Huntley hearing. Moreover, to the extent the prosecution intends to pursue statements listed in the 710.30 notice that do not have corresponding witnesses on the proposed witness list, the court should direct the District Attorney's Office to inform the court and counsel as to how the prosecution intends to admit those statements at the Huntley hearing. In the same email, counsel also noted that there were several potential witnesses that did not appear relevant to the Huntley or MAP hearings. These witnesses include the following: Emily States, Blair County 911 Coordinator, First Assistant District Attorney Nicole Smith, Blair Company, District Attorney's Office, Sergeant Christopher McLaughlin, NYPD DCPI, Detective Amy Johnson, NYPD CSU, McDonald's Video Custodian. On Gregory Caro, November 25, 2025, Anissa Weasel, Danny Senior Investigative Analyst Counsel requested an offer of proof as to what relevance these witnesses had to the hearings. The District Attorney's Office has not responded to counsel's request. Counsel requests that this court direct the prosecution to provide an offer of proof as to the relevance of these witnesses to the hearings. Exhibits for the hearing: we request that the prosecution provide any exhibits it intends to introduce at the hearing in advance, so the defense may determine whether objections are warranted. This will ensure the hearing proceeds efficiently and avoids unnecessary pauses to review evidence or litigate admissibility. Redaction of personal identifying information: we request that Mr. Mangione's address, emergency contact information, social security number, and any other personal identifying information be redacted from all paperwork, body-worn camera footage, and any other material to be used at the hearings. Restraints during the hearings: we renew our request that Mr. Mangione be unshackled during the multi-day hearings so that he may meaningfully participate, take notes, and consult with counsel. If complete removal of restraints is not feasible, we respectfully request that at least one hand be unshackled to allow him to write. Defense requests to call witnesses: the defense seeks to call the following two employees of the Altoona Police Department as part of the MAP hearing: Corporal Garrett Trent and Patrolman Randy Miller. To avoid unnecessary delay, we request that the District Attorney's Office assist counsel in arranging for these two witnesses to be available for the hearing. CC, District Attorney's Office, via email, -3 submitted. Karen Friedman, Anafilo Mark Anafilo, Jacob Kaplan, counsel for Luigi Mangione.
In this document, they basically request, can the alleged writing that was found in Luigi Mangione's backpack, like the alleged letters, also the alleged notebook that was found in Luigi Mangione's backpack, should not be shown. The contents in those letters and also the alleged writing from Luigi Mangione, should not be shown in court when the hearings happen, and they're allowed to use the photo of the front of the book, but they're not allowed to use the writing inside the book. Thankfully, they have not done that at the moment that we know of. It's also brought up in the document. Rockefeller mentions the prosecution does not want this to go forward because literally what they have is inefficient. It is mentioned in the document the prosecution don't want this to go forward because they are unsure because of their legal strategy. I love that. I love Karen's comebacks. Also brought up in the document, the hearing will happen on December 1st, December 2nd, and December 4th, 2025. Again, this is a little bit outdated. We already know it has gone forward by another 3 days, and probably next week as well as me filming this. Bring up in the document the reason why they shouldn't bring up the alleged writing in Luigi Mangione's notebook, and also what was in the alleged letters that were found on Luigi Mangione, because literally it does not relate to what they are discussing, because literally what they're discussing was literally Luigi Mangione's illegal arrest, because they searched him without a search warrant multiple times. They did not read Luigi Mangione's Miranda rights until 20 minutes later, and literally bringing the writing they allegedly found on Luigi Mangione to those hearings do not relate to that whatsoever, so they should not use those writings whatsoever, and that we know of so far they haven't, so that's good. They listened once. And it's also brought up in the document they're not allowed to call Luigi Mangione's alleged writing a manifesto because how prejudiced that wording is. So they're not allowed to use that, but sadly, that we already know of, one of the officers already said that, and the judge said, you can't say that if this actually happens in court. I do want to add this here, by the way. I have seen a picture of the alleged book that was found in Luigi Mangione's bag, and the alleged manifesto writing, it had a spiral backing where the book is combined compared to the alleged writing book they allegedly found in backpack. There we go. It was just a spine book where it was together. Does that make sense? So I just find that interesting. So make that make sense. So they also request this in the document, and I'm not sure why they have to request this when it should be common practice, but whatever. Basically, they request in the document any personal information they use at the hearing of Luigi Mangione's personal information, like full address, driver's license, etc., all that kind of stuff needs to be redacted in any form, like in the body cam footage or photos or anything like that. It needs to be redacted, and I'm quite surprised to do that. I feel like that's common practice, but honestly, we already know this. They love to leak that like we heard in the past. They did leak information with a full document with Luigi Mangione's full address and Luigi Mangione's driver's license to the public in a document, by the way. I do want to add, they've done it in the past. It's not something they will not do. They will do that. Like, they have to have that stuff in writing. They also renewed their request for Luigi Mangione not to be handcuffed and shackled, and like we've seen in the photos that are recently coming out of Luigi Mangione at the court hearings, they did respect that rule, thankfully. But sadly, we still see the dents of how tight the handcuffs are in Luigi Mangione's wrists, of the glimpses we've seen of his wrists in this. Again, very sad. I talked about that early in the video, but I will go into that in more detail on my next video, going over the hearings, just because of how much there is, and it went over 3 days when it was meant to be. It's gone for 6 days now, probably more as we go forward. Again, I will make that its own dedicated video. Normally in this part of the video I would say that's normally all the current information, but this is, again, like I mentioned, just because Luigi Mangione has his court hearing right now and there's a lot coming out and I want to make it its own dedicated video. This is all the information from October 10th 2025 all the way up to November 5th 2025. Now that's all the current information from that time frame. Now we are going to be moving on to my final thoughts of basically everything going on in this moment in time in Luigi Mangione's court hearing. So now we are going to be moving on to my final thoughts and things that aren't really related to Luigi Mangione's case, but I thought they were relevant anyway, but not to put in the major bit of the video like I normally do. Okay. And my one little thing I want to add here that wasn't really relevant to his case, but I kind of feel like I should add here. Again, normally I would have more of these, but I kind of feel like I've already added them in this video compared to what I normally do. The 23rd of October 2025, the Unitedhealthcare basically got sued again for the Medicare sketchy shit they're doing. I just thought I should note that here. Happened again. I normally would have more things here, but honestly, my final thoughts in this entire case going on is just like, oh my fucking god. People need to like stop running with things when people say they know Luigi when they don't. People need to stop running with that. I don't hear things from Luigi Mangione's legal team because they want more Luigi. Crazy, man, how politicalized this entire thing has been. But I am really glad they do have that kind of stuff in writing now, compared to like, we all knew it from the very beginning, but they have it in writing now, Luigi Mangione's legal team at the moment. And honestly, I can't imagine what Luigi Mangione is feeling right now. Hopefully he doesn't know about those people who came out and said a bunch of things about Luigi. I feel like that would hurt him up quite a bit. This entire case, there's been so much going on. Like, I feel like nothing happens in the span of 2 months, and then everything happens in the span of like 1 week in this case. And that's literally what it's been like November 25th. 2025. It's like, boom, everything's happening now. I feel like that was going on in Luigi's case. I do find it quite interesting. Literally just basic things for like, I'm assuming someone to have, like literally having their information, personal information, to be redacted and things should be put in writing, when I feel like that is standard procedure. But honestly, we've seen it many times in the past. The prosecutors love leaking to the public. And I do have a little bit note of like what's going on with Luigi this week. So the reason why Luigi Mangione's court hearing led into this week as well, just because it ran for time, and also Luigi Mangione was sick as well. And I feel like of New York, like how cold it gets in New York, and then also like the stress of the hearings and stuff like that, that would definitely make you a lot more prone to get sick compared to like different circumstances, if that makes sense. I really hope Luigi Mangione's okay. I know those conditions at MDC aren't great to be sick in. I feel like it would be terrible to be there while being sick. And on top of that, you have to go to a hearing the next day. So I hope Luigi Mangione's okay. I've mentioned this a couple of times in my other videos talking about Luigi Mangione, but I just want to keep talking about this every time I notice it happening, just because, you know, it keeps happening and I want to keep noting it happens. So basically around this time as well, I don't remember when, I don't have the time code. My ginormous thing of notes, I don't have the timestamp for this when this happened. But basically another person I follow on Instagram getting information on Luigi Mangione's case, they've also been censored again for basically spreading correct information, like transcripts, files and all that. In Luigi Mangione's case, they have been censored and they're posting stuff, and this stuff has not been seen. Like, they can see it on their side, but other people can't see it whatsoever. Again, I just want to keep noting every time this happens. It's happened multiple times. I've seen on different platforms, not just on YouTube, not just on Instagram, not just on TikTok. Like, it's happened multiple times on different platforms, and also on Reddit as well. And I also, around this time as well, I noticed I think 2 separate accounts down. One was on TikTok and then another time was on Instagram. Thankfully they got their Instagram and TikTok accounts back, but it did happen. Their accounts got taken down and all they were doing was spreading the accurate and correct information. Like, it's very annoying and very frustrating. Like, that's how these social media platforms are like censoring things, when literally, again, it's a very scary thing to censor accurate and correct information. We don't want to live in a world like that, okay? It's scary what they want to do that, when literally, when they say it's there to protect us, when there's literally like on those websites. I'm not joking. If you write the right keywords, you will find it, and it is there, and they won't do a thing about it because it makes them money. I should probably bleep that word, but I'm generally serious. So again, it's fucking insane. That's my little tangent about the censorship stuff. It keeps happening and I'm annoyed about it, and I want to keep noting it every time it happens. And I just want to keep noting every time this happens, just because we need to keep talking about Luigi Mangione. We need to keep all the accurate and correct information about Luigi Mangione out there so people can see it and see what's actually going on in his case, instead of letting the media telling us what's actually going on in Luigi Mangione's case. Like we all know, and we keep saying it, the media does not like Luigi Mangione whatsoever, and the facts they give us is not really the correct or accurate information on this case. And that's why I don't really like all the live tweeting from the court hearings happening this week, because that is just done by journalists that are live tweeting in the actual courtroom itself, and like we all know, the media does not like Luigi Mangione, so basically they could leave out things, or they could like put things in or not have other things in what they're live tweeting because of context. So again, I don't really trust the live tweeting stuff, even if that's the only accurate information we have coming out on Luigi Mangione's court hearings at the moment. Again, that's my little tangent about it. But yeah, the media does not like Luigi Mangione whatsoever, and it's very annoying when the internet and people in the government services are trying to suppress information about Luigi Mangione's case, when literally like all people are doing are just like spreading the correct and accurate information. It hasn't happened to me in a while, but if it does, I'm gonna talk about it. Damn, now I will. And again, I'm very annoyed every time it happens to me, but I'm annoyed in general it happens to a lot of other people as well. Like, why are the people spreading accurate and correct information on this case are being punished and taken down compared to the other social media platforms and news networks talking about Luigi Mangione when it's not correct or accurate information whatsoever? They're allowed to post and talk shit, whatever, about Luigi Mangione, and that stuff does not get taken down. It's very frustrating and very annoying, and I just want to keep noting every time this happens, because it keeps happening, and it's very annoying and very frustrating. So keep talking about Luigi Mangione, keep sharing the accurate information about Luigi Mangione's case. We need to keep doing this because, you know, the media doesn't like to do their job. I do want to mention that happened like a couple of months ago. Their account is fine now, their stuff is seen by other people now, but again, I just want to keep noting every time this happens. I did talk about this in my last video, going over the gossip, drama, etc. about Luigi Mangione's case. I did talk about this a little bit in my video talking about just ignoring the gossip surrounding Luigi Mangione's case, but also around this time, Karen Rockefeller, Luigi Mangione's legal team, came out with a statement. It was more so on their question page on their website than more so a statement, but basically them saying, please don't believe everything you see on the internet, people claiming they know Luigi when they don't. I'm glad they came out and said that. Again, I just think more people just need to come out and have more common sense about things in general. I know that sounds mean, but I'm seeing it more and more, not just in this case, just in general, and it's like alarming. Like, please think. So I am glad they did come out and say something about that, because so much was coming out in like a really small amount of time. It was like a week by week basis at that point. So I'm kind of gonna want to move on. So I kind of been noticing this lately on my social medias, and I just want to say thank you to the people that are like saying nice things and DMing me and stuff like that, and saying I'm doing a lot of great work and stuff. I just want to say thank you. It's very sweet of you guys to say that. I do kind of feel like I should do more, like with this hearing stuff, everything coming out. I kind of felt like I've been on the outside, not knowing what's happening compared to what I've normally been doing with the hearing and stuff like that. I kind of felt like I was in the know, but lately I feel like I haven't, so I kind of feel like I haven't been doing much for Luigi Mangione's case and stuff like that, and I do think it's very sweet and lovely of you guys to like say nice things and saying I'm doing great work and stuff like that. And I'm like getting a little bit uncomfortable. It's just a me thing where it's like, I'm okay if two people tell me I do nice things, and then any more of that, I get a little bit uncomfortable. It's like, oh, okay, thank you. But I do really appreciate it. Thank you. I feel like I should do more in this, and I could do more, especially with the hearing stuff and all that. But like I said, I am sleeping, and I can't keep track of like the things happening on Twitter and stuff. And at times, I do really feel like I could be doing more, if that makes sense, in these type of videos for Luigi Mangione's case. So I do feel like you guys should give your praise more so to Luigi Mangione's legal team than me. I just get all the information from Reddit and then like his website and just dump it in one place. I do my best, okay? So I thank you for being nice and the little praising and stuff like that. Sometimes I don't feel like I deserve it. Thank you. It's very sweet of you to say that. I'm noticing it a lot more. Normally I would not bring this stuff up, but I'm noticing it a lot more, and thank you. It's very sweet of you for all to say that, and I'm glad you like what I'm doing, and I hope it helps Luigi Mangione in the long run with this kind of stuff. I'm gonna move on. I'm gone really shy now. I'm not used to praise. 2 compliments is my limit. Any more, I'm uncomfortable. Okay, now we are moving on. I've been filming this for so long. I started filming this at like, I think 11 a.m. and now it's currently 6 p.m. right now. I've been filming for a very long time. There was a lot to go through, but I hope you guys like it. I've learnt my lesson. Take a month off when you are covering cases like this. It would take forever and a day to catch up, but I caught up, so that's good. And I hope I caught you guys up. That's also good too. Anyway, thank you for watching this week's video. You can subscribe if you want to. It's okay if not. And I upload every week, sometimes 3 times a month, depends what I'm working on. And if you guys want to keep up to date with the channel, that's where I post all updates and what's going on in the Luigi Mangione's case and other things as well in the world. You can follow the channel's social media, so that'll be in the description down below. And if you guys want to follow me personally, all of my social medias are down below as well, if you want to follow me on there. And yeah, thank you for watching this week's video. Bye!